May I kindly to mention item 24 one. There is a mistake in I think
What happened? Item number 24. Specially assigned matter.
actually there is mistake in number. Yeah.
Hmm? (23) ডিটারমিনেশন দিয়ে দিয়েছেন, অন্য ম্যাটার চলে এসছে। নাম্বারটা আমরা ভুলভাল লিখবে, এগুলো দেখা সম্ভব?
May it please your lordship. Your lordship.
I will not be there for 2 weeks. Yes, that's why after that I will take up.
My lord,
May
I
it
have my
please your
lord.
lordship.
Today is not the day of mentioning. Why are you mentioning all?
My lord, I'm not mentioning. Your lordship, I respectfully submit that there seems to be an inadvertent mistake in order. Actually, the order recorded is 2019, whereas the correct year should be 2024.
Again, same mistake. Can number would be 2 of 24
2024.
for correction date.
My lord, may I have my lord kind mention item number 57 of my lord. Today's list, my lord. My lord, I am praying for upgradation. There is extreme urgency. My lord, the petitioner had participated in a process of selection of distributor of a fair price shop, my lord. The private respondent has been selected in gross violation of the vacancy of the requisite criteria as laid down in the vacancy notification.
Item number 57.
57, my lord.
I am for the private respondent in this matter.
My lord.
Let's see, if not today, tomorrow.
My lord.
If not today, then it will appear on tomorrow.
My lord.
Yes, call the list.
My lord, item number 10, I am for the petitioner, my lord.
I am
First
filing the opposition, my lord. in
First
item
read
number
petition.
10, my lord.
In first read petition, my lord, I am for the petitioner. And second read petition, I am for the respondent number 5.
Okay.
My
lord,
second read petition.
Yes.
My lord, before going through the reports, I want to place a short history of this case, my lord.
My lord,
আমি বলবেন
আমাকে তো
আমি তো
বলতে দিন,
petitioner
আমি
first
আপনার-
itemটা আপনি দেবেন, আমিও দেবো আমার
Okay, just wait. Let me hear it out. Why you are obstructing?
Second matter, I am in 11 for the state.
In item number 2, second matter,
Yes, second matter, item number 11.
11.
and my lord,
in item number 10, my lord, I am filing my affidavit in opposition, my lord. Kind.
Very well.
Item number 10.
Yes. You are the petitioner in item number 10.
item number 10, first item 6527, and second I am the respondent number 5. But there is a short history of this case I am placing before your lordship, paying leave, my lord. Now, challenging, sorry, my lord, in terms of a vacancy notice of 2010, I applied for. My name was first position in the comparison chart, but without considering that comparison chart, in 2014, a new notification was issued. Challenging the notification, I filed this writ petition.
Okay.
And the Honorable Court pleased to pass an interim order directing the respondent authorities not to appoint any ME dealer for the village Nanur. And this interim order was extended for until further order. And 2015, this matter was appeared in the list of the Honorable Justice Devashish Kargupta, and his lordship was adjourned the matter without touching the interim order. And my lord, thereafter, 2021, in a Bengali paper, Chopahari, a fresh notification was issued. I served notice to the respondent authorities to withdraw this notice and not to appoint any ME dealer. This notification was lastly cancelled. And in 2022, a fresh notification was issued. This was not my under knowledge. But later on, I came to know that his client has been appointed. And I filed a contempt petition. contempt petition rule was issued. His license was cancelled. And my lord, thereafter he filed an addition of party in my writ petition. Your lordship was pleased to allow this application for addition of party. Challenge that order, I filed the appeal before the division bench, and division bench was pleased to view that he is not a necessary party, not a proper party. His remedy is to file a fresh writ petition, and he filed this fresh writ petition, my lord. So, my lord, when the division bench viewed that he is not a necessary party, not a proper party, then he cannot file a affidavit in the opposition in my writ petition. When he has filed the writ petition freshly, in two way, my lord, my view, my thinking is that in two way he cannot afford.
Yes.
And
So,
my lord,
so today why it is fixed for?
My lord, today is for, my lord,
my lord, I am also filing 3 affidavit in opposition, my lord. One is reply, one is affidavit in opposition, 2 is affidavit in opposition. One affidavit in opposition against recalling application can number 6.
That is item number 11.
No, my lord.
item
Can number
11 is
6,
my writ
10,
petition,
10,
my lord.
10, my lord, there is a can 6 recalling. The state authority respondent has filed a recalling application of my contempt against the contempt application. The challenge in the order of Honorable Justice Aniruddha Roy, my lord. Aniruddha Roy literally viewed that the interim order was continuing. That is why they filed a recalling application.
Who? State authority?
State authority, my lord.
In your writ,
In my writ,
item number 10.
item number 10,
That is 2014 writ.
2014 writ.
Very good. So
My lord, I'm
now,
one by one, my lord, I am filing the
no, Miss Paul, you have filed writ. You file what you file?
My lord, I have filed the affidavit in opposition to their, my lord, writ petition, my lord. With, my lord, I'll kindly come to the order of the division bench, my lord.
No, when division bench.
My lord, division bench, my lord, never directed that we will not file the opposition. My lord, division bench specifically directed, my lord, that both the matters will be heard analogously.
No, whatever may
that
be.
is-
So where the order?
My lord,
my lord, 135, kindly see the page 135 of my affidavit in opposition. I am filing now, my lord.
both the matters will be heard analogously. My lord.
But I am filing this affidavit of opposition against a writ petition, page 135, my lord. Kindly see page 135. Second para, my lord.
MAT
Sir, this is the
2198.
earlier order.
Yes, my lord.
Yes.
Having heard the learned counsel appearing on behalf of the respective parties, this court is of the view that the added respondent Phasi is neither a necessary nor a proper party to the instant proceeding. His right would crystallize only upon the interim order dated 11th March 2014 passed by a single bench of this court as revived subsequently on 7th November 2022 is vacated.
My lord, thereafter, my lord, pursuant.
And
Can we
thereafter,
come
my
to
lord, when he
order
filed the writ petition, my lord, both the matter was heard by their lordship, and their lordship then directed your lordship to dispose of both the matter analogously, my lord. And second, next page 137, my lord. But my lord, by mistake or correct by my lord, your lordship has passed an interim order in his writ petition without hearing my writ petition, my lord. And against that order also, I have also prepared an appeal, and that appeal was heard. But now it is his lordship, their lordship, pleased to release the matter, and it had to be assigned for another bench, my lord.
Okay.
My lord, item number 11 is my matter.
So, my lord, I do not know whether, my lord, your lordship would please to direct me to file a reply against the affidavit of opposition or not.
No. Miss Paul, you are not a party in 2014 writ petition.
My lord,
Why are you
that-
filing the affidavit?
But my lord, thereafter, my lord, by virtue of addition of party application, my lord, before your lordship allowed the addition of party application, and my lord, that pursuant to that application, my lord, we have been added as the respondent number 5 in their writ petition, my lord.
No, what was the,
Yes, my lord.
And this is
Pursuant to
the
your
order,
lordship's
my lord.
order, Pursuant to your lordship's
Your
order.
lordship was pleased, but challenging that order, I filed the
Yes,
appeal.
yes, my lord.
And appeal court has viewed that, my
no,
lord.
appeal court is the order is there.
But appeal court, my lord, there is no bar to that I am not a party, my lord.
File. When you are not a added respondent, how
But
can you
I have been added as a respondent prior to
that order has been set aside by the
That-
appellate
oh,
court?
but no, it is not set aside.
Yes, that is the
No,
order. You
that-
read the order.
No, no, that is
You
not
are
set
not
aside.
a proper party or necessary party.
Yes,
How
sir.
can you be a party in
But
this
my lord,
matter?
thereafter, my lord, their lordships gave leave.
Yes,
my
directed
lord.
that both the read
So, my-
can be
Yes,
filed.
now,
Both
my,
the read. So you
both-
come with the read.
my lord, I have filed a fresh writ petition, my lord. That
Very
is
well.
item
So
number 11.
who are you in this read in 14?
14, my lord. If, my
You
lord,
are nowhere. You cannot file this. In 14, you have no locus standi to file any affidavit. Okay. You can come in item number 11 with your pleadings, everything.
Yes, my lord. I have filed the affidavit in opposition in,
Affidavit
but
in
my lord, kindly
opposition.
come.
Have you served it?
yes,
Affidavit in opposition in item number 11.
11, my lord.
Okay.
And I am also filing an affidavit in opposition against the recalling application filed by the
state.
state, my lord.
Very good.
This is one, my lord. And my lord,
You serve the copies.
yes, my lord, I have already said. Huh? And list of the 6, item number 6. My lord, here is the one question is there, my lord. The recalling against the order of
Calling application. That is item number 11 in
no, my lord. In item number 10, my lord. Item number 10,
10.
can 6, my lord.
Can 6 is listed.
Listed, my lord. But my lord, here is,
So why you
but
filed
my
before
lord,
this court?
I know, my lord. That is my question. That is my question, my lord. But the division bench, their lordship were pleased to direct your lordship that to heard the both the writ petition along with all the application.
No, I cannot hear it out.
Yes, my lord.
Whether I can hear it out?
Yes, my lord.
Not at all.
Well, since, my lord, both the writ petitions are directed to be heard, my lord, analogously, my lord. And my lord, my application as an addition of party, my lord, that should be also considered by.
And she already disposed of.
It was allowed, but
That
turned
was
down. How can I? You are not a party in the item number 10.
But for my proper adjudication of the case, my lord,
You can file affidavit in 11.
very well, my lord. Now
File it,
they
file.
have filed the affidavit in opposition, my lord, to my writ petition. I shall file the reply,
Yes,
my
you
lord.
file the reply.
And my lord, in my writ petition, my lord, your lordship, after hearing, my lord, your lordship has directed, my lord, kindly come to the order dated 4th April 2025. Your lordship passed the order in my writ petition, my lord.
Item number 11.
Item number 11. Since, my lord,
No, what are you submitting?
my lord, affidavits are not yet completed, my lord. Since I have received the opposition yesterday only to my writ petition, so my lord, I need time to file
Very
reply, my lord. And my lord, the interim order which is subsisting in my writ petition, that should be extended today, my lord.
My lord, one objection is there, my lord. I have not filed any application for extension of
lord,
application.
Only
No, I cannot hear both of you.
my lord, the writ petitioner, my lord, he is the licensee, my lord. He is continuing with the dealership, my lord. He has been appointed under a fresh notification in 2022, my lord. My petitioner,
So where is the interim order?
my lord, 4th April 2025, my lord, passed by your lordship, my lord.
4th April.
My lord. Hope na.
হ্যাঁ আমি দিয়ে দিচ্ছি আপনারা দেখুন।
Where is the order? 4th April?
My lord, I'm handing over the order.
No such order is there.
My lord, I'm handing over the. In my writ petition, my lord, in item number 11, my lord.
কি order করে?
In item number 11.
Okay, item number 11. Udhay, it 10.
Item number 11, my lord.
Okay, okay. It 10. So,
Your lordship has directed for restoration of the license of the petitioner, my lord, and pursuant to your direction, my lord, the license has been restored, my lord, and my lord, the petitioner is now continuing with the business, my lord. So, my lord, let the interim order be extended, my lord.
okay.
My lord, may I submit, my lord?
Yes.
My lord, this is an affidavit in reply against the affidavit in opposition filed by the state respondent in connection with my writ petition, my lord.
In connection with your writ petition.
Sir,
Okay.
Thank you to the ST. Time নিয়ে নিন। আমি দিয়ে দিচ্ছি, সব দিয়ে দিচ্ছি, সব রিসিভ দিয়ে দিচ্ছি। আপনার ক্লার্ক রিসিভ করেছে, না করলে কি আমি বলি? সাহস আছে কোর্টের সামনে মিথ্যা কথা বলতে পারি?
Item number 11 is separate, my
Yes,
lord.
my lord.
That is separate, my lord. I have,
If I exist,
If
my
I
lord,
am
if
not-
I do not exist, then he will come, my lord. And if I exist, then he will go.
I have been appointed under a fresh notification, my lord. Fresh vacancy
ঠিক আছে, আপনি সেটা
notification
বলবেন,
in
please.
2022. And my lord, that notification has not been challenged by them, my lord. So
Not
my lord, they
necessary.
have not agreed with my license. An area cannot be injuncted for several years.
No, I understand. Both the writ petition has to be heard together. This is the
But in
order of the division bench. I shall hear both the writ petition.
My lord, my
No issue.
submission is
But
kindly
when-
fix
what-
a date. Kindly fix a date
All
for it.
pleadings complete? No.
my reply, yesterday only, my lord, I have received the
You
opposition.
have received the reply against the CAN application? Okay, you collect it. Very well. July.
My lord, my lord, three my lord, filing had been recorded. My lord.
Yes,
I have filed 3 affidavit, my lord.
yes.
That should be recorded, my lord.
I shall record it, but the matter that is the CAN.
But your lordship will not be pleased to heart, but can be recorded that it is
Yes,
on the record.
very
Fine.
I didn't know. এগুলো দাও তো। No, what about the affidavit of state in respect of item number 11? Report or affidavit or report. So you have to file it. Because I have to hear both the applications. Both the writ petition I have to hear. So I am fixing a date in the third week of July. Within that you place the you file that reply. Okay. লিখো। হেডলাইন হেডিং করো WPA 6527 of 2014 দেখো affidavit in reply on behalf of petitioner to the affidavit in opposition file on behalf of the respondent number 1 to 5 be taken on record. Full stop. Petitioner, next paragraph, also file an affidavit in opposition against application for recalling filed by the state respondent. Let the affidavit in opposition be taken on record. Full stop. It appears that pleadings are complete. Let the matter fixed for hearing under the heading to be mentioned. July 23rd, 2025. হলো দাঁড়ান দাঁড়ান আছে লিখুন WPA 7138 of 2025 ওপরে সব হেডিং গুলো সব থাকবে পরপর যেরকম হেড করে দিচ্ছে এরকম করে affidavit in opposition file on behalf of respondent number 5 be taken on record. Full stop. No affidavit is placed by the state respondent. Let the state authority be given liberty to file the affidavit in opposition within 2 weeks from date. On such, the petitioner shall file reply within a week. Full stop. Next paragraph. Petitioner seeks to extension of interim order passed by this court on 4th of April 2025. Having heard the learned counsel for the petitioner, also concerning the submission of the learned counsel appearing on behalf of the respondent number 5 and the state respondent, and also perusing the order passed by the Honorable Division Bench that both the writ petition being number WPA 7183/2025 as well as WPA 6527 of 2014 shall be heard together, shall be heard analogously, comma. Let the matter appear for hearing along with writ petition number 6527 of 2014 on covered 23rd of July 2025. Full stop.
Along with the
Interim order passed by this court. Next paragraph. Interim order passed by this court on the earlier occasion is further extended till August 8, 2025 or until further order, whichever is there.
My lord, kindly submission, report my lord submission. Objection against my lord's extension of interim order.
Yes.
Because they have not filed any application for extension of interim order.
There is no requirement for filing
Very
any
well.
application.
No,
Okay,
application.
I'll
Kindly,
what the-
kindly,
what the
madam.
লিখবে? Having heard the learned counsel for the respondent number 5 লিখেছি না?
There is no such requirement.
ওটা লিখেছি দেখো। Who raised strong objection against the extension of interim orders.
Not along with the writ petition application, contempt application also be heard, madam.
Yes. Both the writ petition shall be heard together.
But the writ petition and along with application, one application contempt is also pending. And division bench direction was there, along with all the application. Since
Okay.
your lordship would not be pleased to heard the recalling application, but your lordship has no bar to heard the contempt application.
If the contempt is there along with that.
Yes,
I
madam,
shall-
contempt is
take
there. Contempt number.
Contempt application is not listed.
But contempt is not in the
8
list.
of 2023 contempt application.
It was not listed.
But they have listed item number 8, application 8, but no application there is indicating 8.
Item number 8.
8, application number 8. Kindly see list. Item can number 8, but there is no can 8. সেটাই তো।
No can 8 is there. No
Yes,
can 8.
my lord, no can 8.
But,
6, 7 and 808.
CPN has to be listed.
Can,
CPN was not
matlab, can
listed.
number is 808. CPN number 808 of 2023. It may be,
I will check out. I will check out.
it may be singly on 8.
Okay, very well. Call the next matter.
Lord, I appear for the petitioner.
Lord, I am appearing on behalf of the state.
Lord, I tell you, Lordship, why this has come. Lord, this has come for recording of compromise. Lord, I tell you, Lordship, something has happened in between this, Lord. Lord, this matter was made part heard by your Lordships, Lord, on 20th January 2023. কোথায় পাবো বল?
Very old matter.
Yes.
I must have forgot everything.
Sir, I am appearing on behalf of
I
the
tell you, Lordship, what happened now, we, all of us missed that. So we got this,
This is the Sierra.
CRR. But this
It was
I
uttered by me when I was the dimension.
yes,
So
Not-
what happened there?
I tell you. But this was the 482 application was filed praying for quashing of an FIR. The allegation was that the de facto complaint, my learned friend's client, she alleged that her father has lost the DSC, director signature, and thereafter there has been some transfer of shares. We, my lords, warned your lordships initially that the shares were transferred upon making publication and all that. The proceedings were stayed. It did not proceed. There was a matter taken up by her before the NCLT. NCLT also did not interfere. Then the parties entered into a settlement. NCLT already withdrawn, suit filed already withdrawn. Now this matter was agreed to be withdrawn. Now there were total in the FIR 12 blood accused. 5 of them are petitioner in this petition. Rest 7, they took out an application for addition of party so that in one go, my lord may dispose of the entire matter. Lord, all of us missed that it was made part hard by my lord. We, my lord, mentioned the matter before my lord Justice Choitali Chatterjee. Her ladyship initially allowed the application for addition, called for the report from the police station whether there has been a settlement or not, and the status report from the court below. Everything came. Her ladyship, while passing the order, realized that this is a part hard matter. So by a subsequent order, the earlier order has been recalled and it is sent to your lordships. Lord, this is the order making it part hard, my lord. I am handing over to your lordships. My lord, may একটু কোর্টের ফাইল থেকে বার করে দিন, এটা রাফে প্রিন্ট করেছিস কেন?
Order dated?
20th January 2023.
No, what is the order of Potter?
Part 20th January 23. 20 January.
Yes,
My lord has got that.
yes.
That is your lordship's note, perhaps. All of us missed it. We blood a broken bench. We mentioned it. We got it listed. Now my lord, kindly see the thereafter order. Now kindly have a look at the order dated 16th of May by এটা কেন মার্ক করেছো? কোথায় মার্কিং করা আছে? 16th May. এটা তো ফ্ল্যাগ করবে, এটা ফ্ল্যাগ করার দরকার নেই। But kindly now see 22nd May order. Although this has been recalled, but this was the order passed by my lord Justice Choitali Chatterjee. 22nd May order. But I'm just placing the order for your lordships. But kindly have a look at the top. There are CAN 5, CAN 6, CAN 7. But CAN 5 is filed by the original petitioners for recording compromise before. CAN 6 is for addition of party by my learned friend appearing for the other accused, and CAN 7 filed by the other accused for recording compromise. So if 6 is allowed, 7 can be taken up. Now kindly see what was the order, although this is recalled now. The criminal revision application under 401-482 has been filed by the petitioner for quashing of the order dated 31st passed by the learned additional chief judicial magistrate arising out of Boranagar PS case number so-and-so. At the time of admission, this criminal revision application pursuant to direction to an interim order stay was granted, which was continued. In the meantime, parties have settled the dispute by virtue of memorandum of understanding entered into by and between the de facto complainant and all other petitioners. It is submitted that out of 11 accused persons, 5 persons came up before the court with the criminal revision application. The rest have filed CAN 6. Matters got that? For adding them as the petitioners in the proceeding, a copy of the same has been served upon the state. It is admitted by all the learned advocates appearing for the parties before this court, that including the learned advocates appearing on behalf of the de facto complaint, that there is a settlement between the parties, and the present application have applied for addition of parties who are the main accused persons in the charge sheet. Considering the fact that the application for addition of party being CAN is allowed, let the proposed applicants be in the application of additional party be added as petitioners in the criminal revision application. Department is directed to incorporate necessary corrections. Department has also perhaps done the corrections. It is further submitted by the learned advocate for the petitioners that 2 joint compromise petition, CAN 5 and CAN 7, have been filed for recording joint compromise. The copies of such application have been exchanged between the parties. At this stage, pursuant to the submission made on behalf of the state, the court of the learned 5th Judicial Magistrate Barakpur is directed to submit a report regarding current status of the GR case number arising out of Boranagar within 1 week reopening. Inspector in charge Boranagar is further directed to submit a report ascertaining as to whether any compromise has been effectuated between the parties pursuant to the memorandum of understanding. But these 2 reports came to the court. Now kindly take the next order, 18th June. the last order. My lord, kindly got that? But it's my duty to place this also. Learned advocates of parties are present. Today the matter has been listed under to be mentioned. It is noted while taking up the matter that the matter has come up in the list pursuant to the mentioning on 15th May by Mr. Swanso, learned advocate, appearing for the applicants in CRAN 6. The matter was mentioned before the court without divulging that the matter was part heard by a coordinate bench. On Hato, the matter was, however, listed before this court for the first time on 22nd May, and the learned advocates for all the parties had appeared on that day, but none of the learned advocate of the parties pointed out the fact that the matter was part heard by another court earlier. CRAN 6 was disposed of on the day without having any knowledge of the same, and certain directions were passed. Today, the learned advocates appearing for all the parties are present in court and have tendered their unqualified apology for not pointing out that the fact have submitted that the matter is pending since 2018. Inadvertent mistake has been made by them. This court makes it clear that such conduct of the parts of the advocate who are officers of the court is not appreciated, as well as the department who sent the case record on the basis of the requisition of this court without having a careful examination. Since the order date 22nd May was passed without having any knowledge of the matter was heard in part by another bench, and other order so and so, the same stands recalled. Let the matter be released forthwith and placed before the department, place it before the appropriate bench. So, my lord, this had to be passed, my lord, because 22nd May order could not have been passed since it is part heard by your lordships. Today, my lord, all the applications are here. My lord, the reports have come. My lord, may for the present kindly consider CRAN 5 once. CRAN 5.
My lord, this is a very old.
Is a compromise application.
Yes. Filed by the original petitioners. Kindly take CRAN 5 once. Barcode the one. Lord, it will be on the bond paper. It is A4 paper. CRAN 5. My lord's got that?
Yes.
Lord, kindly straightway come to page 17. The memorandum of understanding. Lord, although Justice Chatterjee recorded everything, still it's my duty to show it to your lordship since it is coming up before your lordship. Lord, kindly see details of the parties. Gourango Pal, and kindly come to page 19. Genia Paul. Gourango and Genia are Lord father-daughter. And then kindly see details of the second parties. Manura Begum, Samsu Alam, Tapos Mondal, Associated SB, Dimple Choudhury. Associated SB Industry Private Limited is the owner of piece and parcel of land so and so. Then Lord, kindly take page 21. Owing to various disputes and differences arisen between the parties, following civil and legal criminal proceedings have been initiated pending. Proceeding before the Company Law Board. Colors kindly got that. Then kindly see complaint by Genia Paul. This complaint and first information report, Bodanagar PS case number 668, not page 22. And then complaint of Gourango Pal. Then particulars, table number 3. Particulars, applicant name Manura Begum, quashing of the proceeding. This particular revisional application is mentioned. And post initial, they kindly come to 23, post initial of the proceeding, detail 1 and 2 and 3. On the intervention of friend well wishers, the parties have amicably resolved and compromised the dispute between and have arisen between the parties as per terms of the MOU. As per the amicable settlement dispute, different parties agreed, first party, second party, and now therefore they will withdraw according to MOU. So, my lord, showing this, I took out CAN 5, and my lord, the other accused, they took out CAN 6 and CAN 7. So, my lord, CAN 6 was allowed, but for this technical reason, the order has been recalled and sent it to your lordships.
CAN 6 for addition of party.
CAN 6 for addition of party. So, my lord, subject to your lordship's kind consideration, my lord may today again allow CAN 6 and can my lord consider all the applications and disposed of. Because the state is here, their report has come, Lord, the IC has verified the fact that Mr. Bordon will tell you, lordship, but the report Mr. Bordon submitted this on the last occasion before Justice Chatterjee also. But due to this technical thing, it could not be disposed of. Mic now.
My lord, the report dated, my lord, 16/6/2025, my lord, that is the compliance report regarding the recording of statement of the de facto complaint and the other accused persons. My lord, kindly have a look. My lord, I've got it, my lord. report from the IC Honorable, my lord. But the original is, my lord, kept on record. My lord, I have, my lord, the another copy.
Report কই?
এই অরিজিনালটা দেয়া
তোমার কপিটা দাও না
আমি তো বলছি
I think that is the one.
ইয়েস my lord.
Yes.
But kindly have a look, my lord, the defective complaint Genia Pal's statement was recorded, whether my lord, the compromise has actually affected or not, and her father's statement, my lord, Gaurango Pal, that was also recorded, and my lord, through email, my lord, it was sent to the, my lord, all the accused person, and in reply, my lord, they have also stated, my lord, the compromise has affected between the parties, my lord.
And well, the allegations were also civil in nature. With regard to transfer of shareholding of a company, now money has been paid, they have no grievance, NCLT has disposed of the proceeding.
And my lord, we have annexed, my lord, all the compromise petition and other. And my lord has also seen, my lord, I know, my lord, that the report from the court below has come regarding the stage of proceedings, my lord.
Where is the report?
রিপোর্টটা দেখান তো
ব্যারাকপুর কোর্ট থেকে একটা রিপোর্ট এসেছে, ওটা জজ সাহেব বার করে দিন। Lord, should I find it out for your lordships from the file? অনেক মোটা বড় ফাইল হয়ে গেছে। I think that is the report. In fact, the LCR is here in this court. তাই তো LCR ও এখানে আছে। So the stages can be ascertained from there also.
No status report.
That I don't know. But the LCR is here, that your lordship called on 19th December 22, my lord called for the LCR.
LCR has been received.
LCR has been received. So from there, the status can be ascertained.
But where is the report from the magistrate?
That oh, it has come. রিপোর্টটা কোর্ট ফাইলে থাকতে হবে, কোর্টের অর্ডারে হয়েছে তো। ওখানে
Okay, give me the LCR.
LCR
My lord, your lordship's order 19 December 2022 records that LCR has been received. Then your lordship was hearing it day to day basis. So then LCR was called for. Probably sitting in court number 551, that building. আমরা 11 থেকে ঘুরে আসবো চলছে এটা আমার
5 মিনিট দাঁড়িয়ে যাবে বা বলে যা বলে যা বলে যা বলে যা।
সামনে আছিস তো ওখানে 11 অর্ডার দিতে শুরু করলে যাবো তার আগে যাওয়াটা ঠিক But what I was praying before my lord is my lord may today Lord allow can 6 and thereafter Lord 5, 6, 7 may be disposed of not causing the proceeding along with the CRR.
Okay. So who appearing for 6? The Tran 6. You are appearing. How many petitioners are there in
Lord, in
can
the
7?
Lord,
Can 6? Can 6? 6. So total 11 or 12? 11.
11. Lord, the 156.3, my lord, take up the original revisional application once. I just tell your lordships. The 156.3 applications, your lords will find at page 28 of the original revisional application. There are total 11 accused persons. Now, amongst these 11, 1, 2, 3, 6, and 7, they came for in the original revision. My lord, is that page 28? Can you take page 28?
Total 11.
Total 11, this Manura, Dimple, Rupsona, and in the next page, Samsu and Jakaria. They are the original petitioner in the CRR. Now the rest 6 have come through CAN 6.
Very.
This is a very old application. Whatever has happened
You are-
that time, I am for the opposite party number 2, de facto complainant.
Okay.
Well, now the matter has been settled between the parties, and we don't want to wish to proceed the matter. Nothing remains now. Everything has been settled between the parties.
Very good. Please take down.
Lord, may I take your lordship's leave? One matter
Yes.
is called. But Mr. Nondi is here to assist your lordship.
Grant 6 of 2025. This is an application for addition of parties filed by the petitioners, filed by the intending intervener to this proceeding, who are the rest charge-sheeted accused persons in connection with GR case number 5955 of 2016 arising out of Varanagar Police Station case number 668 of 2016, wherein charge sheet has been submitted against them by charge sheet number 448 of 2017 dated 28/7/2017 under section 420 stroke 467 stroke 468 471 476 120B 506 of IPC. Now the GR case is pending before the learned Judicial Magistrate 5th Court, Barrackpur at North 24 Pavana. Full stop. It is the contention of the petitioners that intending interveners that other charge sheeted accused persons has filed the instant CRR praying for quashing of the entire criminal proceeding against them. Full stop. It is the further contention of the learned counsel for the petitioner that the matter has been settled outside, settled between the parties through a compromise outside the court. On the strength of said compromise, the other pending proceeding between the parties has already been withdrawn. The petitioners has also filed one application being CAN 7 of 2025 for recording compromise.
My lord, the petitioner has filed CAN 5. The CAN 7 has been filed by the other charge sheeted accused.
For the grant 6 applicants, they have filed grant 7.
5 is for settlement, 6 is for addition of party.
And 6, the petitioners, in 6, they have filed CAN 7.
Applicants, they are applicants. Petitioners, we are the applicants.
That is the recording.
that
I am
is-
passing the order in CAN 6 only, not nowhere. I have understand. Yes. Petitioner, intending interveners. Petitioners Staccato, intending interveners, has also filed an application being CAN 7 of 2025 for recording joint compromise. For the learned counsel for the petitioner further submits that for effectuate disposal of the instant matter, the petitioners are required to make party in the instant proceeding. Full stop. Learned counsel appearing on behalf of the de facto complainant as well as the state respondent, as well as the state has assented to the contention of the contention of the intending interveners concerning the submissions. The applications being CRAN 6 of 2025 is considered and allowed. Full stop. The intending interveners be made party as respondent in the instant CRR. Full stop. Accordingly, CAN 6 of 2025 is disposed of. Next paragraph. CAN 5 of 2025, CAN 7 of 2025. Both the applications are filed for recording joint compromise effectuated by and between the de facto complainant of the instant criminal proceeding with the other accused person, with the other charge sheeted accused person. Full stop. A coordinate bench of this court at the time of taking note of the instant CRAN applications has directed the concerned inspector in charge Varanagar Police Station to submit a report ascertaining as to whether any compromise as ascertaining as to whether any compromise has been effected between the parties pursuant to the memorandum of understanding as placed before this court on 6th day of July 2023. Full stop. The coordinate bench has also directed concerned judicial magistrate to submit a report. Both the report has arrived to this court. I have perused the report of officer in charge, Boranagar Police Station, wherefrom it appears that the concerned police officer has interrogated the de facto complainant, namely, what is the name? Jinia Pal, as well as
Our father,
Gaurangopal.
our father Gaurangopal, to ascertain the correctness of the fact. From I have also perused the statement recorded by the police, wherefrom it appears that both the de facto complainant and her father has voluntarily disclosed before the police authority that they have entered into a amicable settlement for which they did not want to proceed with the instant criminal proceeding.
and also, my lord, the sent through email to all the accused persons, and in reply, they have also stated that the compromise has been.
The matter has the concerned police officer has also sent the fact also informed the fact to the other charge sheet accused persons through mail. They also replied to the mail that the fact of amicable settlement is correct. Next para, a report from learned judicial magistrate 5th Court Barrackpur has reached, who indicated that the LCR has been called for by this court during the proceeding of the instant CRR. Full stop. I have perused the LCR. Full stop. It appears from the LCR that the trial has not initiated yet. Full stop. Next para. In considering the joint compromise petition between the parties, it appears that parties has entered into a memorandum of understanding on 6th day of July 2023, wherefrom both the parties, whether all signed,
Yes, ma'am.
all signed,
Lord, she is represented. She says that everybody has signed this.
not signed by all the parties.
My lord, the complainant signs. My lord is looking at CRAN 5.
Yes,
My lord, CRAN 5. My lord, kindly look the complainant signs at page 17. The left-hand corner, my lord.
who are the persons signed there? Jinia Pal, Gaurangopal.
Yes, my lord. This is
That
the
is
complainant.
they are the de facto complainant.
They are the de facto complainant.
And who are the other persons? Not all the parties.
Lord, this is entered between the petitioners in CRR and the complainant. Now, these parties.
How many petitioners are there in the CRR?
CRR, my lord, there are 5.
There are 5.
Yes, my lord.
There are no signature of 5 persons.
My lord, kindly looks Monura Begum, Dimple Chaudhary, Rupsona Begum, Sheikh Samsu Alam, and Zakir Mohammed. My lord, they are parties to the
They have not signed.
my lord, particulars. My lord, kindly look from page 17, 19, my lord, the particulars of the petitioners in CRR. Jinia Paul, Monura Begum, Sheikh Samsu Alam, Taposh Mundol, Mrs. SB, my lord, and Dimple Chaudhary.
The signature of Sheikh Samsu Alam and Manuara Begum,
Sheikh Samsu Alam is written in Bengali.
Bengali.
Page, yes, my lord. Right, can you look at my lord? Page 19, page 17 also, my lord. Page 17, down below, just my lord, just the column, my lord. Sheikh
Okay.
Samsu Alam.
And Manuara Begum,
Manuara
not signed.
No, no, yes.
M. Begum, my lord, for Associated SB Industries.
Okay.
M. Begum. M. Begum.
1, 2, 3, 4. Okay.
My lord, may I indicate, my lord, parties are not willing to proceed with the entire.
Okay, okay. Just I am ascertained.
No, no, my lord. That
Okay.
is a duty, my lord, of ours,
Yes.
my lord, to.
Very good. তারপরে? Settle all their disputes and they are intending to withdraw all the proceedings between them. I have perused the signatures of all the petitioners and the de facto complainant in the joint compromise petition. Full stop. Next paragraph. This is an application for quashing under section 401 read with section 482 of the Code of Criminal Procedure. Prayer for with a prayer for quashing. Now, this is an application under section 401 read with section 482 of the Code of Criminal Procedure. Praying for quashing of the criminal proceeding being GR case number 5955 of 2016 arising out of Boranagar Police Station case number 668 of 2016 dated 4/9/2016 under section 420, 467, 468, 471, 476, 120B, 506 of IPC, wherein the charge sheet has been submitted by the concerned police station after completion of investigation, by charge sheet number 448 of 2017 dated 28/7/2017 under section 420, 467, 468, 471, 476, 120B, 506 of IPC. Now the criminal proceeding is pending before the learned Judicial Magistrate 5th Court, Barakpur. It appears that full stop. It appears that the dispute between the parties has been settled outside the court. Full stop. Next para. Now considering the situations herein, wherein an application under section 482 CRPC has been placed before this High Court for quashing a criminal proceeding, but the parties had settled the dispute outside the court. Full stop. Having considered the merit of the instant CRR, also considering the fact that there are civil disputes between the parties for non-payment of money or for allegation of sellout of the shareholdings without permission of other shareholders of the company has been settled between the parties. It appears that the dispute between the parties are civil in nature, wherein they have entered into compromise between themselves. At this juncture, I find no justification to proceed with the instant criminal division. under the above occupation, the instant criminal revision being CRR 3254 of 2018. Is disposed of by recording the settlement between the parties arrived at, recording the memorandum of understanding arrived by and between the parties on 6th day of July 2023. Full stop. The next paragraph. The criminal proceeding pending before the learned Judicial Magistrate 5th Court Barapur being GR case number 5955 of 2016, arising out of Boranagar Police Station case number 668 of 2016. Is hereby quashed, including
Charge sheet. When proceedings was charge sheet is included.
Proceedings was for
where in the charge sheet has been submitted. It is charge sheet number 448 of 2017. 8 of 2017, dated 28/7/2017. Is hereby quashed against all the accused persons. Is hereby quashed. Full stop. CRR 3245 2018 is disposed of. Full stop. Connected applications, if pending, are also disposed of. Connected applications being CAN 567 2025, along with other applications, if pending, are also disposed of.
The only thing that the applicant will be again a part. They feel that is given now.
Yes, I have passed the order already. I have disposed of the.
Wait for my. Wait.
Call the list.
13.
Number 13.
Lordship, I am appearing on behalf of the state. There was a direction to file a report. Everything has been done except it has not been affirmed. I am just praying for not this week. If it can be taken up next week.
On the prayer of the learned counsel for the state, the matter be adjourned for this week.
Grateful, Your Lordship.
In my lord, I am appearing for the prior respondent, my lord. Respondent number 6, my lord. But my lord, rejoined.
Also file kora
Rejoined by the respondent number 6 to the reply to the opposition. Supplementary.
report is of December 24.
So rejoinder against the.
So we have
affidavit-
filed a report already in this
affidavit
matter.
reply by the petitioner.
Well, we have already used a report in the form of affidavit. But now this supplementary affidavit, your lordship will kindly not allow. Then it will be indefinite. Everyone will come and file a supplementary affidavit. It is their writ petition. They have given the document they want. We have given a reply to it. After disclosing my stand, now a supplementary affidavit after 6 months. Many things may happen over 6 months. But he will have to maintain his writ petition on the basis of the grievance as on the date of filing of the writ petition. What has happened thereafter, is immaterial.
Yes, this is the rejoinder. Now, what is the reply?
No, there is a rejoinder to the supplementary affidavit also.
Petitioner filed supplementary affidavit much earlier, I think.
Just before vacation.
That is also quite belated.
Just right. Come to the report, affidavit in opposition. Everything is ready. Yes.
To complete his argument, my lord, since my lord, the respondent number 6 is my lord led by Mr. Lakri, my lord. Due to his illness, my lord, he is not in a position to come today, my lord. He will argue tomorrow. Let the petitioner, my
You can start today.
lord.
Then for not tomorrow, after
Then let
I-
it come in August, my
Yes,
lord, after
yes.
your lordship circuit bench.
after I come, the matter will appear.
Because license has already been given. Let them run the shop. Respondent number six.
You know, tomorrow is.
Petitioner is not interested, then what can be done?
Can you also take it up tomorrow?
I do not know whether it will be possible or not.
It is not.
I have to check my diary.
Very well, we'll come back.
Important matter, my lord.
Then, my lord, my prayer is kindly take it up in August. That is my prayer.
So I wanted to do it like equal. It's not completely.
Very
Yeah,
well.
my lord, both have prayed adjournment. My
If you
lord,
lordship feel,
my lord, both have prayed adjournment. State is praying adjournment till August.
if you lordship feel, my lord, if I finish my submission tomorrow, you can take it up tomorrow, then I will.
No, it
Conference
is
next.
not your direction like that.
Senior, it is like he has come to the senior for conference that, sir, I cannot come today, I'll come
Yes.
tomorrow.
It will appear in
My
the.
prayer is that kindly take it in August.
Very good.
License has been given, let it run then. If the petitioner is not interested, then what can be done?
I think Mr. Bosman misheard it. I made myself very clear, my lord. If not going to do it peaceful manner, I will have ready today, my lord, as I have done it. It is because, my lord, the tribe responding, they asking for time. I said, let's not do it in peaceful manner.
Not
Very good.
before, not before 15th July. Not before 15th July. Yes, that is the situation, you know.
Then
And
let it appear on the monthly list of August.
tomorrow I have fixed several matters. You know the matters. Then how can we? Yes, please take down. Rejoinder on behalf of the respondent. Number 6, to the affidavit in reply of the petitioner. To supplementary affidavit be taken on record. Learned counsel appearing on behalf of the respondent number 6 seeks accommodation. Let the matter appear in the list on. ষোলো তারিখ কি আছে 16 জুলাই একটা very good 16th of July at 2 p.m. I want to hear out all the matters. Okay, 16th of July at 2 p.m.
Item number 15.
Lordship,
Professor Shaktipada Kundu.
my lord, we have, my lord, taken the, my lord, point of maintainability of the writ petition. My lord, kindly, my lord, takes my report in the form of affidavit affirmed on. Lord, this is 28th February 2025. My lord, we have taken the specific ground.
28th February.
Kindly, my lord, takes paragraph 3 thereof at page 2. My lord, we have taken certain points of maintainability which I will be arguing, my lord. So, my lord, the issue is, my lord, clause 32, my lord, of the control order of 2013. My lord, kindly, my lord, they are challenging, my lord, an order of the district controller food and supplies. My lord, where, my lord, they have been also, my lord, imposed by with a penalty. Kindly takes 32 in the blue book. Lordship has it, my lord. Page. This is 1.34.
Yes.
Lord, I am placing it.
Appeal.
Yes, any distributor aggrieved by an order of the district controller, food and supplies, denying the issue or renewal of the license to the distributor, or cancellation of the license, or imposition of the fine, may prefer an appeal to the director DDPS within 30 days. Kindly notes. There is a time frame which has been fixed. So the mechanism is a time-bound mechanism. 30 days of the date of receipt of the order, and the director shall, as far as practicable, dispose of the appeal within a period of 60 days. Again, my lord, a time frame has been given from the date of receipt of the appeal, after giving the person a reasonable opportunity of being heard. So, my lord, there is a mechanism in place for appeal. Now, my lord, kindly takes the second paragraph. If the distributor concerned is aggrieved or dissatisfied with the order of director DTP&S, he may prefer an appeal to the secretary to the state government within 30 days. Again, time frame given from the date of receipt of the order passed by the director DDPS. The secretary to the government of West Bengal Food and Supplies Department, upon receipt of the appeal, will dispose of the same within 60 days after giving opportunity of hearing to the appellant. Now, my lord, kindly takes for a moment, my lord, the prayers in the writ petition. It is at page 16 thereof. My lord has got it?
Yes.
Kindly sees. Issue a writ in the nature of mandamus, commanding the respondents to refund stroke replace 30 metric ton of rice supplied by the petitioner to the respondent Panchayat Samiti in emergency situation arising out of flood in 2015, together with the change of 1920.67 quintals of inferior rice for the purpose of maintaining smooth distribution of food amongst flood affected people at Arambagh for filling up the deficient stock of rice of the petitioner without causing any further delay. Kindly notes, and to further refund the penalty of rupees 17 lakhs and to act in accordance with law. My lord, he is aggrieved by the penalty as well, and my lord, he wants that stock of rice to be replenished. Now, my lord, kindly, my lord, I am relying on, my lord, a couple of judgments of the Supreme Court. My lord, in case where, my lord, the alternative remedy is present, my lord, and a statutory mechanism which is in a time-bound fashion, my lord, there is a possibility of exploring this remedy. My lord, if the petitioner does not explore the remedy, my lord, the rule of discretion of the Honorable High Court and the Supreme Court will be that, my lord, they will not entertain such a writ petition. Well, it's a question of self-imposed restriction, but the discretion has to be, my lord, exercised judiciously. My lord, I am relying on the judgment of Titagore Paper Mills Company Limited and another versus State of Orissa and others. I am handing up the copy. This is reported in 1983, Volume 2 SCC, page 433. 1983, Volume 2 SCC, page 433. My lord, kindly takes paragraph 6. Four double three.
Yes.
My lord, kindly takes paragraph 6. My lord, I am placing it. We are constrained to dismiss these petitions on the short ground that the petitioners have an equally efficacious alternative remedy by way of an appeal to the prescribed authority under subsection 1 of section 23 of the Act, then a second appeal to the tribunal under subsection 3A thereof, and thereafter, in the event the petitioner gets no relief, to have the case stated to the High Court under section 24 of the Act. In Raleigh Investment Company Limited and Governor versus Governor General in Council, Lord Utwat J, in delivering the judgment of the board, observed that in provenance of tax, where the Act provides for a complete machinery which enabled the assessee to effectively raise in the courts the question of the validity of an assessment, denied an alternative jurisdiction to the High Court to interfere. Now, my lord, my lord, they have, my lord, discussed, my lord, how, my lord, this case was. My lord, I am going to, my lord, to the next page. My lord, the quoted portion, kindly takes of that judgment. 438, my lord, the quoted portion in construing the section,
Yes.
it starts with. So, in construing the section, it is pertinent in their lordship's opinion to ascertain whether the act contains machinery which enables an assessee effectively to raise in the courts the question whether a particular provision of the Income Tax Act bearing on the assessment made is or is not ultra vires. The presence of such machinery, though by no means conclusive, marches with a construction of the section which denies an alternative jurisdiction to inquire into the same subject matter. So, my lord, my argument is, in the present case also, my lord, there is a specific statutory remedy. My lord, if they go to the appellate authority within the time frame given, my lord, it is also, my lord, speedy. Kindly notes that 30 days you have to approach, 60 days therefrom, then you again have a time frame for the second appeal.
Yes.
My lord, this was available to them, which they have not exhausted. Kindly takes paragraph 11 of that same report. At page 440.
Your report?
My lord, of the, my lord, the judgment, I meant.
Okay, judgment.
Yes. The same judgment, my lord, the Titagore paper, Mr.
Yes. Paragraph
11.
11.
My lord, it says, kindly, my lord, takes paragraph 11. Under the scheme of the Act, there is a hierarchy of authorities. Same with us. First appeal, second appeal. Before which the petitioners can get adequate redress against the wrongful acts complained of. The petitioners have the right to prefer an appeal before the prescribed authority under subsection 1 of section 23 of the Act. If the petitioners are dissatisfied with the decision in the appeal, they can prefer a further appeal to the tribunal under subsection 3 of section 23 of the Act, and then ask for a case to be stated upon the question of law for the opinion of the High Court under section 24 of the Act. The Act provides for a complete machinery to challenge an order of assessment, and the impugned orders of assessment can only be challenged by the mode prescribed by the Act and not by a petition under Article 226 of the Constitution. It is now well recognized that where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by that statute only must be availed of. This rule was stated with great clarity by Wills J. in her Wolverhampton New Waterworks Company versus Oxford in the following passage. There are three classes of cases in which a liability may be established founded upon statute, but there is a third class where liability not existing at common law is created by a statute, which at the same time gives a special and particular remedy for enforcing it. So, my lord, the order, my lord, which they are coming up against, my lord, there is a, it is not that there is no, this is not a simpliciter, my lord, an order of the administrative authority which is placed before the review before your lordship for a judicial review. My lord, there is a specific remedy of appeal. My lord, so my lord, that goes, my lord, with the statutory mechanism, my lord, replaces, if that mechanism was not there, then my learned friend's client would directly come to the High Court. But because that mechanism is there, my lord, they must first exhaust that mechanism.
Yes.
And my lord, I'll go so far as to say, my lord, the appellate authorities, my lord, are quasi-judicial authorities. My lord, if they are aggrieved by the order of the quasi-judicial authority in the first appellate or the second appellate stage, they'll still have the chance to come before this court in judicial review of that order. But first, they must exhaust that remedy. They have not even bothered to, my lord, approach those authorities. My lord, then, my lord, I am just placing that the remedy provided by the statute must be followed, and it is not competent to the party to pursue the course applicable to cases in the second class, where there is no statutory mechanism provided. So when mechanism provided, different path. When mechanism not provided, another path. Here mechanism provided, so the specific path must have been taken. The rule laid down in the passage was approved by the House of Lords in Neville versus London Express Newspapers Limited and has been reaffirmed by the Privy Council in Attorney General of Trinidad and Tobago versus Gordon Grant and Company Limited, in Secretary of State and Secretary of State versus Mask and Company. It has also been held to be equally applicable to enforcement of rights and has been followed by this court throughout. The High Court was therefore justified in dismissing the writ petitions in limine in entirety. Now, my lord, the other judgment I am relying on, my lord, I am handing up a copy.
Yes.
This is, my lord, Union Bank of India versus Satyavati Tandon, the celebrated judgment, my lord, of the Supreme Court, reported in 2010, Volume 8, SCC 110. Well, this pertains to, my lord, proceedings under the Surface Act, my lord, because, my lord, there is a particular remedy provided under Section 17 of the Act. My lord, the writ courts, my lord, in fact, my lord, Supreme Court deprecated the practice of the writ court entertaining the writ petitions where there was a specific mechanism provided. Kindly, my lord, takes paragraph 42 onwards of the judgment at page 123.
Yes.
My lord. Page paragraph 42. There is another reason why the impugned order should be set aside. If respondent 1 had any tangible grievance against the notice issued under Section 13(4) or action taken under Section 14, then she could have availed remedy by filing an application under Section 17(1). The expression "any person" used in Section 17(1) is of wide import. It takes within its fold not only the borrower but also the guarantor or any other person who may be affected by the action taken under 13(4) and Section 14. Both the tribunal and the appellate tribunal are empowered to pass interim orders under Section 17 and 18 and are required to decide matters within a fixed time schedule. My lord, kindly marks the word fixed time schedule, which is again, my lord, parimetria with our case. And my lord, another, my lord, expression, my lord, I stress upon is at page line 3, could have availed remedy. My lord, here also, my lord, they could have availed the remedy, they did not. Now, my lord, parad 43. Unfortunately, the High Court overlooked the settled law that the High Court will ordinarily not entertain a petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person, and that this rule applies with greater rigor in matters involving recovery of taxes, cess fees, other types of public money, and the dues of the banks and other financial institutions. My lord, I draw an analogy. Here also, my lord, the question of 17 lakh fine, my lord, this goes to the public exchequer. So, my lord, and there is a mechanism. It is not that they are left without a remedy. Please go and avail that remedy. That is all, my lord, we are submitting. In our view, while dealing with petitions involving challenge to the action taken for recovery of public dues, etc., the High Court must keep in mind that the legislations enacted by the Parliament and the state legislatures for recovery of such dues are a code unto themselves, inasmuch as they not only contain comprehensive procedure for recovery of the dues, but also envisage constitution of quasi-judicial bodies. Well, same with our case, quasi-judicial bodies for redressal of the grievance of any aggrieved person. Therefore, in all such cases, the High Court must insist that before availing remedy under Article 226 of the Constitution, a person must exhaust the remedies available under the relevant statute. My lord, again, my lord, I had made this point before. My lord, I am not saying that he is remediless. He can avail those remedies as in accordance with law. And my lord, if those remedies do not, my lord, he is aggrieved by the remedies granted to him, he can always come before this High Court under a judicial review. Because it is a quasi-judicial authority, order is amenable to the High Court, to 226 jurisdiction of the High Court. Now, my lord, paragraph 44. While expressing the aforesaid view, we are conscious that the powers conferred by the High Court under Article 226 of the Constitution to issue to any person or authority, including in appropriate cases, any government, directions, orders, or writs, including the 5 prerogative writs for the enforcement of any rights conferred by Part 3 or for any other purpose, are very wide, and there is no express limitation on exercise of that power. But at the same time, my lord, kindly notes this part, my lord, kindly, my lord, marks this part. We cannot be oblivious of the rules of self-imposed restraint. My lord, tomorrow, my lord, lordship knows, my lord, these statutory mechanisms, and my lord, the alternative remedy, my lord, this, well, there are exceptions, which is there, my lord, lordship knows those judgments, but I am on the point, my lord, that when there is a remedy available, which is, my lord, time bound, my lord, what is, my lord, the remedy? It has to be speedy, it has to be efficacious. My lord, the filing of the appeal kindly sees, my lord, it does not even have any special cost. So, my lord, there was a Supreme Court judgment, my lord, where they said that equally efficacious, equally cost effective. Well, there is no question of cost in filing the appeal. He could have easily gone there. He did not. Now, we cannot be oblivious of the rules of the self-imposed restraint evolved by this court, which every high court is bound to keep in view while exercising power under Article 226 of the Constitution. Number para 45, it is true that the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion. But it is difficult to fathom any reason why the High Court should entertain a petition filed under Article 226 of the Constitution and pass interim order, ignoring the fact that the petitioner can avail effective alternative remedy by filing application, appeal, revision, etc. Here, my lord, the appeal. And the particular legislation contains a detailed mechanism for redressal of his grievance. So, my lord, appeal, second appeal, if they are not happy, they can come to the High Court. No one is preventing them to do so. But why come before this court? And my lord, lordship knows, my lord, all these alternative forums, the tribunals, these quasi-judicial authorities were precisely created to, my lord, reduce also the load of the High Court. Because tomorrow, my lord, everything under the sun will be, my lord, brought before the High Court. And where you have a remedy, please avail. And then if you are not happy with it, judicial review is always open after that also. Now, my lord, 46. It must be, my lord, I am skipping over 46. I am going directly. My lord, the 46, there is only one part. My lord, this is on the point of granting of stay. My lord, it says that, my lord, in the next page, 124, in cases, my lord, second line, in cases relating to recovery of dues of banks, FIs, secured creditors, etc., High Court would have serious adverse impact on the financial health of such bodies, stroke institutions. My lord, public exchequer. That is what it is, which ultimately prove detrimental to the economy of the nation. Therefore, the High Court should be extremely careful and circumspect in exercising its discretion to grant stay. But more importantly, when it kindly takes para 55 at page 128 of the judgment.
55.
My lord, page 55, para 55. It is a matter of serious concern that despite repeated pronouncement of this court, this is the Supreme Court, the High Court continues to ignore the availability of statutory remedies under the DRT Act and the SURFACI Act and exercise jurisdiction under Article 226 for passing orders, which have serious adverse impact on the right of banks and other financial institutions to recover their dues. We hope and trust that in future, the High Courts will exercise their discretion in such matters with greater caution, care, and circumspection. So, my lord, I would also say, my lord, not only alternative remedy, my lord, this writ petition is also premature. They have to pass through those stages, then come before your lordship. They have
What is
chosen.
the writ petition about?
My lord, kindly takes.
What is the writ petition about?
My lord.
What is their prayer? They have
Kindly.
already deposited the 17 lakh.
Right, right.
They want the refund only.
My lord, refund will be given from the public exchequer.
Not only that, they have also submitted that there are some flood and they have supplied some food grains
My lord,
to the flood affected area.
my lord.
I want to know whether any of the prayer of the petitioner was ever considered.
My lord, they never made the prayer to the authorities. My lord, they could have made these prayers before the appellate authority.
Not appellate authority. What did? by the concerned authority, by the subdivisional controller.
My lord, lordship is coming to the
District
merit
controller.
of the case. My lord, I am on the maintainability of the petition
I
at this point.
understand. No, I understand.
But the
your
other-
submission,
Hmm.
if there is anything, any order passed by the authority concerned, first
Hmm.
authority concerned,
Hmm.
regarding their grievances, if they prefer appeal
Hmm.
against the order of imposing punishment, that would be decided. But this is not the matter herein.
My lord, they have definitely, my lord, kindly takes.
I understand your submission. Your submission is very correct. If there is a one line determination by the authority concerned, then the appeal would be there. And
My lord, the imposition of fines have been, my lord, made by the authorities only. And my lord,
after
kindly,
inspection, they have made such.
my
fine
lord, the
and they
show
have
cause
given-
notice, my lord, was issued by the district controller
Yes.
at page 27. My lord, before going to these facts, my lord, the other thing is, my lord, the quantum of, my lord, the punishment, my lord, the penalty, my lord, what exactly had happened. These are the questions of fact. My lord, that is my other, my lord, point which I have taken in my
I am not
report
going
also.
to that. I
Lord,
just
because-
want to know, I to substantiate your submission regarding alternative remedy in appeals under section 30, under chapter 32, clause 32. I want whether the appellate authority, if they at all appear before the appellate authority,
My instructions
if,
are no.
if their grievances would be ventilated there,
Yes, my lord, that
how
is
can it
there.
be?
My lord, kindly takes the show cause
See-
notice.
See the show cause notice. Is there any point regarding?
Then, my
earlier
lord, there was a
supply
hearing given on 29th by the district controller. If they were,
on the basis of show cause notice?
yes, absolutely. And my lord, thereafter the punishment was imposed.
Where is the show cause notice?
My lord, at page 27. My lord, again, my lord, before going to that, my lord, I also want to, my lord, argue on the proposition that writ court cannot reappreciate the evidence. My lord, because an appellate authority is there, because writ is not an appeal. My lord, this has been well settled, my lord. I do
Yes,
not
yes.
have a,
The appeal.
there is kindly, my lord, bear with me for a moment. My lord, this, in the judgment of, my lord, I do not have a hard copy thereof. My lord, the judgment of State of West Bengal versus Atul Krishna Shaw, 1991 Supreme Court. This was, my lord, held that by process of judicial review, court cannot appreciate the evidence and record its own findings. My lord,
I am not going to hear about the merit of the fine imposed
Right.
upon them. They have also not paid for the merit of the fine imposed. They are here before this court that the fine amount may be refunded as because they have supplied earlier the food grains. This is the matter whether the authority
kindly,
ever heard that.
kindly takes page 32.
Yes. Imposition of penalty.
My lord, this
They
is
have
the order they are
deposited.
agreed with.
They have deposited, not agreed.
No, they want a refund. They have deposited
Fund on the
with the
other
prayer of
ground,
refund.
not the grounds you have assigned regarding the imposition of fine. They have admitted you have imposed fine. They have not any grievance against the imposition of fine. They have no grievance.
My lord, I put a question to myself. My lord, in the prayer, my lord, they are asking for refund of the fine.
Refund of other grounds, not that grounds. Why, in which ground you have imposed the fine?
No.
Go through the writ. Yes, they have not agreed against the imposition of fine. They are not at all agreed. They have not made a single comment about the imposition of fine.
My lord, the imposition of fine, my lord, is the challenge. Refund the penalty.
No, refund the penalty on the basis of other grounds, not the grounds we have imposed the fine. They have admitted.
So very well, my lord, that imposition itself is under challenge.
No, imposition not challenge. Imposition, fine imposed, they have paid. They admitted your imposition of fine. They have never raised any point that such stocks are not there, nothing else. But they have raised grounds that earlier that stocks was delivered elsewhere. This is the reason they have appeared before this court.
My lord, that is, my lord, whether, my lord, earlier the stocks were delivered elsewhere. It's a question of fact.
No, whether the authority has ever considered that. That
My
is
lord,
the only ground.
the question is, my lord, for the authority to consider, my lord, they have to, my lord, make a representation to the authority.
They have made a representation. There are
Yes,
representation.
and if the authority does not give due credits to the representation or does not dispose it of, then they have an appellate remedy. Appellate remedy is not always against an order.
Then
It is
you
also
have to
refusal to pass an order.
Then you have passed an order. You have to pass an order. Where is the order?
Kindly seize, my lord. Yes, page 32. Apropos above, this is to inform you that a penalty of 9 lakh only has been imposed due to non-satisfactory results. Comes during the hearing subject to the matter stated in the order sheet. You are requested to deposit the mentioned amount. So, my lord, if they do not have a grievance with this, my lord, how can they ask for the refund of the amount which has already been paid?
That is the writ about.
That is a different thing. My lord, the question of merit is, my lord, whether, my lord, the quantity of stock was there or not there, whether there was a shortfall or not there. These are, my lord, the inquiries in respect of facts of the case. My lord, I am only on the point that imposition of penalty, my lord, even the claim of refund, my lord, they have made a claim. Kindly seize. To whom? To, my lord, the Honorable Minister, I am ignoring that. My lord, 36, to the District Controller. Kindly seize. আপনার অবগতির জন্য জানাই,
You read page 37.
yes. My lord, these are, my lord, the questions of fact. My lord, if today, my lord, kindly, my lord, first of all, my lord, appreciate this. My lord, because today, if lordship goes into this factual query, my lord, I put a question to myself, my lord, this representation dated 12th May 2020. My lord, the representation made to the district controller, if kindly sees the tenor of the language of clause 32, if they are not happy with the disposal of this representation, my
What
lord,
is the disposal? Is there any disposal?
no,
of
if
that?
there is no disposal, then they have an appellate remedy.
How can it be?
Because that is the action of the district
No,
controller.
by an order, there must be an order to go to the appeal.
Right.
You see, 32.
There was, my lord, the inspection also and everything done.
Funny matter is that they have not challenged imposition of fine. They have not challenged in this.
They want the refund of the money paid.
For other grounds. That's it. That is the writ all about, not your imposition of penalty. Nothing. They have not raised.
My lord, today,
at least
if
in
they
this
had,
petition.
not deposited that penalty amount,
They have deposited.
my question is, my lord, to myself, is that today, if they did not deposit this penalty amount, can there be any question of refund? My lord, is it not the fact that when an amount which has been deposited and, my lord, the position is taken that that amount should be given back to me, is it not that the amount was not collected rightly from me?
No, they have not raised any single point that amount was not collected.
Then, my lord, on what basis they will get back the amount?
That is the writ about. You see the writ.
That is why, my lord, because their claim for refund has not been entertained by the district controller,
They have not
they could have challenged.
They have not made any prayer for claim of refund before the district controller. That is not.
Then, my lord, for the first time, a mandamus will be issued coming to the writ court. My lord, without making up demand for justice, can a mandamus be issued? I put a question to myself.
Prayer is not that. Prayer is otherwise. You read the prayer A.
Yes, my lord.
Refund is subsequent.
Kindly, my lord, bear with me for a moment. I'll just wait. Yes. The prayer is
in respect of refund replace of 30 metric ton rice.
yes.
That is
My lord, where is the my lord? There are two parts of the prayer,
Yes.
and my lord, kindly sees there is a conjunction and to refund.
Yes, and to refund.
So, my lord, this prayer stands with the prayer for refund, and my lord, this prayer also, my lord, to refund replace 30 MT of rice. My lord, this prayer has to be made before the district controller. Then the district controller refuses. then my lord, you go up in appeal, then second appeal, you don't get a remedy, you come to this court. My lord, even if, my lord, if, my lord, today, even if they have not made a prayer to the district controller, my lord, even then the writ petition is not maintainable, not only for the want of alternative remedy, because, my lord, a mandamus, my lord, cannot be issued without, my lord, there being a specific demand and, my lord, a refusal to grant that demand. Well, I have some judgments and that as well. Well, today I don't have the copy. Well, keeps it. I'll tomorrow itself keep it. I'll submit those copies.
No point of stop. He is saying that I have not made any representation to the district controller, praying for handing over the material. He should go through the repetition first.
Very well. My lord, kindly.
If you want to kindly allow me, I shall not take more than 10 minutes. Merit, maintainability, everything.
My lord, I'll cover, my lord, two aspects of, because, my lord, these issues came up during the course of hearing. My lord, I'll cite 2-3 other judgments on the point of this. My lord, regarding the mandamus, and, my lord, also, my lord, regarding, my lord, the scope of inquiry of the Honorable Writ Court.
Oh, is there any adjudication at the
My lord, hearing was
page
given.
36, 37? Is there any adjudication by the authority?
Hearing was
That's
given.
the admission. That I am entitled to get the entire.
There was a hearing given.
10 minutes.
My lord, on merits, my lord, kindly keeps it tomorrow. I'll submit those judgments. Then my learned senior friend will.
I understand your judgments and you
Yes.
have placed this. But the matter is that when you have arguing on the point of appeal, the provisions of alternative remedy is there. But there is nothing in the by which the petitioner can go to the appeal. There is nothing order. No order is
My
there.
lord, the petitioner can challenge the action of the district controller in appeal.
That's why they have challenging here.
But why in the writ petition they have that appellate remedy? I just put this question I
How
put to
they
myself.
can appeal without an order?
My lord, refusal to pass an order is also appealable.
So see, if it is appealable. Clause 32 is specific saying about an order,
Yes.
not the refusal.
My lord, or my lord, kindly sees distributor agreed by an order of the district controller
So
denying
order-
issue or renewal of license to the distributor or cancellation of license or imposition of fine.
That means there must have an order. Where is the order?
My lord, the imposition of fine order is there.
They have not challenged. They have not challenged in this writ
My lord,
petition.
they
At
want,
least
my lord, it is
in
doing
this petition.
something indirectly instead of doing it directly.
No.
My lord, kindly, my lord, keeps it tomorrow. I'll some more judgments. My lord, even if for my own satisfaction, my lord, my learned senior friend is here. He is there.
They have not pleaded a single line regarding your fine, imposition of fine.
My lord, my lord, cover that aspect as well. My lord, I'll just submit a 2 or 3 judgments, and my lord, I'll close that argument. Then my lord keeps it tomorrow.
Also, my lord, what submission is being.
My lord, my learned senior friend is here. My lord,
What is the submission? What is my case? He has not gone through the repetition. Let I place your lordship, my lord, 10 minutes.
my lord, I accept, my lord, the reprimand from my learned senior friend, my lord, as a matter of teaching, my lord, I'll come back.
This
But kindly
is that
keeps it tomorrow.
tomorrow I cannot fix this matter.
Any day as your lordship wants.
I have the urgency.
Tomorrow,
My lord,
Again, 2 crores rupees fine has been imposed. Again, for the
Keeps it-
same reason.
well, that is, my lord, perhaps not the matter of
In that
challenge in
case,
this writ
lordship,
petition.
kindly stay the portion of that order.
My lord, in another writ petition, my lord, he has not challenged that. My lord, keeps it, my lord, day after tomorrow, even if your lordship, it comments to your lordship.
yeah,
But I'll finish the submission on that.
What submission? What submission my learned friend will advance?
very well. Day after tomorrow, not possible.
In that case, my lord, your lordship kindly protect me by passing an order of status. Because this thing will continue. Now, this is the question of the state advocates. Raise preliminary objection regarding maintainability in every matter. Kindly see true court's fine has been imposed during pendency of this petition on the same ground.
কটা আছে? দুটোই কটা আছে কালকে
True court 61,25,000 during pendency of the petition.
परसों किया है ग्रुप 1
দেখিয়েছি আমি বলেছি যে আরো দুটো একটা ডকুমেন্ট দেখাবো ঠিকাদারটা দেখিয়েছি
সত্যপতি কান্না
দেখিয়েছি এখন পরে বলছি এটা আমি একটা judgment দেখাবো
সাইডে 12টা সাইডে 12টা হ্যাঁ
আমরা আসছি
কটায় না 10:30 একটা দিয়েছি তো। Ten 30.
very well
Not
no, I'm
earlier.
led by Mr. Sengupta he's just arrived
I'm sorry minute I was in another court minute
14th at 10:30.
very well
Argument on behalf of the state continued. Argument on behalf of the state on the point of maintainability continued. Let the matter appear in the list on 14th 14th of July 2020 at 10:30.
Because they are not ready, they say that they want to show some judgment.
Okay.
That is the call.
কিছু টিভিতে মনে হচ্ছে আমাকে কেটেই ফেলে দেবে আমি কি
15,
সুস্থ
16 both 15, 16 15, 16 both. Yes. Fifteen, 16 both.
14 July,
14th of July 10:30
10:30 for further argument.
for further arguments.
One week.
Yes.
78. Lordship, in this, I'm seeking 1 week more time. Yeah, you have not been warned, you have been politely requested.
Lordship may extend me.
An accommodation is sought for on behalf of the state for extension of time to file affidavit in opposition on behalf of the state. Let the matter be adjourned today. Filing for affidavit, filing for report in the form of affidavit be further extended for further 2 weeks. List the matter.
I will learn
16th of July.
prayed only for a week, my lord.
You have forgotten that the next week Lordship is not there.
Well, I should get time to file my
Yes.
exception. Lordship has kept it on 16th.
Yes, 16th of July.
Or contempt, but then appeal is pending and that will be heard out on Thursday. State has preferred an appeal, so Lordship kindly adjourn the matter for some time or go out of list, regarding to mention.
Okay.
Order.
Please take down.
Next Thursday possibility is fixed, my lord. Kindly Direct the matter, go out of list, leave what you to mention.
Yes, learned counsel appearing on behalf of alleged contender submits that in the appeal being MAT 835 of 2025, the Honorable Division Bench has already stayed the impugned order passed by this court. Having heard the learned counsel for the parties, the instant matter be go out of the list, parties are liberty to mention.
Go to continue.
You can read it. It is.
My lord, just now I have obtained the affidavit. Just now.
May I most humbly
one
submit
second.
what is the subject of this that we have filed before your lordship? Have a look, sir.
Second half, my lord, after 2 p.m.
No, today.
Just now,
Today it's not
at
possible.
least 1 hour before or half an hour before you could
Not
give me.
possible. Today it's not
1
possible.
second I have got it. 1 second before.
Shut it up. Then next week, sir.
No, next week, no. Today I am ready to complete it.
Today I have some other matter at 2 p.m. I have fixed matter. You
My lord, after 15 minutes, after
no, that is not the way to hear before the High Court.
just
You
now I have obtained, my lord.
that very well. You take your time. What is the difficulty? You take your time.
If they are so interested, your lordship, they
No,
can
why
always
not?
No, they are
send a reply.
interested. Obviously, they are interested. No.
Why not in the Why should I come before honorable court?
you please
At
take
least,
time to
at least,
reply.
please
Okay,
try
okay.
to
You read
understand
it.
that you are here for a long time. I am also here. You could give me at least 15 minutes ago.
Very
I
well.
could go through it.
You keep your time. You keep your time.
My lord, then I should request after 4 or 5, honorable court will not be available up till 14.
Yes.
That's why then I should submit before your lordship. That,
Yes, you can.
After my lord, 15, 16,
Very well.
17,
20, 22,
22.
22. Very well. Please take down. Affidavit in opposition on behalf of the state respondent be taken on record. Let the matter appear in the list on 22nd of July 2025.
My lord, with folded hands, my request. I am coming from far. It should be top of the list within from 1 to 10, so that in that date I can use the
He
file.
can always appear virtually also, sir.
No, that is another matter. Within 1 to 10 the top list, if it is possible, then that date I will get the chance. Otherwise,
Always I am taking your matters every day.
the
it
ma
is
two days like this happened. 2 days I could not submit. That's why I am requesting, if possible, my lord. If possible, if possible. It's my request. I'm a request only.
If you want the matter would appear at top, then it would be August, not earlier
No,
than
no,
that.
my lord. It's July 22.
Already I have fixed some matters.
Oh,
10:30
within
like that.
1 to 15, from serial number 1 to 15, I will
It is
get
within 1 to 15.
today
This is now running within 1 to 15.
Today it is 20, no? 20 it is.
20, the other matters are 2 p.m. matters.
Okay, okay.
And you see your list.
Okay.
Okay. 22 on the same position.
আপনি virtually appear করুন না কি আছে
ডেটটা নষ্ট হতো না, আপনি একটু আগে দিলেন না কেন?
সব ভুল আমারই কি করব
অনেক আগে থেকে কিছু করছেন ভুল।
আচ্ছা ঠিক আছে বহুত
If you want to
হয়ে
use
গেছে।
the reply, you can use that.
ক্ষমা
Within
করবেন।
before that.
Petitioner leave to use reply within the urgent date.
Grateful, your lordship.
I am for the private respondent number 5 led by Mr. Shah Rai, my lord. This matter
Who is for the petitioner?
My lord, I am for the state led by Mr. Janto Samanto.
my lord, this matter also related with the matter in item number 18 and 19, the same license, disputing the same license.
My lord, on the last occasion, that is 13th of May, your lordship had directed the filing of the report from the state. My lord, I have it.
ফাইল হয়নি তো আমাদের পক্ষে
কপি দিচ্ছি। ফাইল তো অলরেডি হয়ে গেছে।
ফাইল হয়েছে
হ্যাঁ, হ্যাঁ, ফাইল হয়ে গেছে।
হয়েছে কোর্টে ফাইল হয়েছে
কোর্টে ফাইল হয়েছে?
So there was a direction by the from your lordships to file the report by the state authority. We have complete our part by filing the opposition and served to all of them.
Yes, where is the report?
My lord, I have the copies of the report, but I'm not sure yet that whether it has been filed or not.
So far as my recollect my memory, my lord, the learned
Respondent number 6, who is the respondent number 6? And you are for the respondent number 5.
Yes.
No report placed. Yes, where is the report?
My lord, I have the copies of the report, but I'm not sure whether the original is filed or not.
No, no. You have to file the report in the form of affidavit.
Yes, my lord. It is ready. I have the copies, but I'm not sure whether the original has been filed or not.
Give me the original.
Original.
In course of day, I will supply, my lord.
Have you served the copy to the other?
No, my lord.
My lord,
Just now.
Just now I have seen it.
My lord, I will hand over the original in course of the day, my lord.
Okay. Mr. Joyanto Samanto, learned counsel appearing on behalf of the state submits that the report in the form of affidavit has already been shown and it would be handed over to this court and copy of the same has already been served upon the parties.
But just now, my lord, sir.
Okay, parties. Mr. Samanto has undertook to submit the affidavit within the course of the day. Private respondent as well as the petitioner is a leave to file reply stroke exception to the report within 2 weeks from date. Within 2 weeks from date. Let the matter appear in the list 28th of July 2025 under the same heading.
My lord, may I submit the original in course of the day to your lordship's officer?
Course of the day.
My lord, I will. Grateful. Well, extremely sorry, my lord. It has been kept.
Where is the original?
It is kept in my chamber.
Okay, you call it.
Here, I'm ringing, my lord. Grateful, my lord.
Lordship,
কোথায় 32? হ্যাঁ এটা কি আমার কাছে কেন করেছিলাম?
Paschim Mednapur, the urgent situation of the flood situation of the Paschim Mednapur. Lordship
Who
kindly.
is appearing for the petitioner?
I already informed you.
Let the petitioner come, otherwise have Kanai.
The district manager personally present.
Okay, so I have to hear the petitioner first. I understand the district magistrate has come. You just inform district magistrate so that I can take it. Yes, you inform the petitioner so that he can
I
come.
already informed you, Lord. Petitioner already come.
Bring him. Okay, call him. I am calling him. Yes, next matter.
The vacancy matter on last occasion when it directed me to serve a copy.
Yes. It is.
And serve the copy to the Bible. And bole diche আগের দিন. And this is the division bench order which I have placed before Lordship on last occasion also. Paragraph 10, I am paying for admitted position today. License has not been granted. Even I am paying for paragraph 10.
My lord, may I remind, my lord, your lordship, that this is the matter which I had mentioned before your lordship.
Yes, sir.
yesterday.
Yes,
The
the
second,
license has not been not granted.
yes, that has gone down wrong, my lord. Unfortunately, my lord, there is a lack of communication.
Paragraph 10, I am praying for this. It's the division bench order. And I don't think why on last occasion Lordship directed me to serve copies, because division bench never says to serve copy. Similar situation. Possibly that may be the contrary to the spirit of the order of the Honorable Division Bench. Hundreds of matter in not a single matter, there is a direction to serve notice to the person concerned who has been granted license.
Yes.
No license. I watch in a
Yes.
impression that license has already.
Full impression.
Okay. Please take down. That is the 2013 control order.
My lord, may I, my lord, most humbly request, my lord,
Yes.
if your lordship so deems fit, only to record, my lord, that the license has not been granted, but the stage is that offer letter has been issued, and my lord, the necessary money has been paid. The conversion certificate of the land is awaited.
So
My lord,
offer letter
issued.
Offer letter issued.
My lord, money paid
Before conversion.
and we do not know whether the conversion is
doubt for challenge.
Okay.
yes.
And order of conversion awaiting.
Awaited to be my lord submitted. It is awaited by the petitioner.
No conversion.
Yes.
In a pond.
No, that may not be the case. And my lord, I believe, my lord, your lordship will be passing the usual orders your lordships have been passing, my lord. In that event, my lord, may I simply, my lord, request your lordship to, my lord, just incorporate in the order, my lord, in bullet points, my lord, our, my lord, submissions against this matter.
Yes.
My lord, may I just read out? First is, my lord, action is of 2023, when, my lord, NFSA was not implemented across West Bengal. Therefore, no, just record. No, implemented across West Bengal. Therefore, in view of the proviso,
all the points being considered by the division bench.
yes,
My lord,
my only
arguments-
request is that this argument may be, my lord, incorporated in the judgment. That's all. Nothing else.
Yes. What is your submission?
My lord, first submission is, my lord, the action is of 2023, the vacancy notification, when NFSA was not implemented across West Bengal. Therefore, in view of proviso, my lord, to clause 1, subclause 2 of 2015, my lord, control order, the action is sustainable. Number 1. Number 2, my lord, of course, corollary, there is a delay, a huge unexplained delay of 2 years. And my lord, therefore, my lord, number 3 is, even after implementation of NFSA and promulgation of the control order of 2024, action cannot be faulted because there are 2 points in this. Action is to be judged on the anvil of the laws then prevailing, which is, my lord, CO of 2013. And number 2 is, even your lordships are, my lord, inclined to consider the action in the light of the 2024, my lord, control order, then under clause 68 of 24 control order, the action is saved. Action already taken under previous control orders are saved. So, my lord, this is point number 3. There are 3 more points. My lord, there is no fundamental right in doing business with the government, especially as a licensee. So, my lord, the petitioner cannot claim for, my lord, any writ on the respondent authorities, since there are no fundamental rights available to him or any other rights. My lord, detagging does not infringe right and does not cause prejudice. This is the penultimate point I have.
Yes.
That, my lord, even if it is said that they have some semblance of a right, my lord, their heart of the argument, the sheet anchor of the case is that they are being prejudiced because of detagging. They had X number of, my lord, ration cards, where from, my lord, something is being taken out and they are left with a lesser amount. But this detagging does not, my lord, infringe any of the rights of the petitioner, my lord. That point is no more, my lord, res integrate. It has been settled. And, my lord, my last point is that there is no repugnancy. My lord, they have said that, my lord, the control order of the state is repugnant to the, my lord, act and the control order of, my lord, central government. However, my lord, they have not been able to demonstrate, my lord, there is nothing. There is nothing to demonstrate that there is repugnancy, since, my lord, repugnancy to happen, there must be a positive assertion, my lord, in the control order of the central or the act, against which another positive assertion in the, my lord, control order of state must be in conflict. My lord, everything has been left on to the state.
Very good.
There is no, my lord, parameter set by the, my lord, control order of the central government or the act, which has been flouted in this case. These, my lord, are the broad points of my objection, my lord. Recording this, my lord, if I may pray, my lord, with the lordship may be pleased to pass the orders.
Very good. Please take that.
Grateful, your lordship.
Similar order যেগুলো হয় কোনটা বলো MAT 1543 of 2021 হয়েছে এখানে লিখবে অ্যাড করবে learned counsel appearing on behalf of the state respondent submits that the there is no repugnancy between the central TDPS 2015 as well as the State Control Order 2013. He further submits that the petitioner do not have any fundamental right in respect of the order of detagging by the concerned department of the state authority, as the fundamental right of the present petitioner has not been violated, thus the instant writ petition is not maintainable. Full stop. After having heard the learned counsel for the party. Affidavit by 3 weeks, reply 2 weeks thereafter. The state respondent has also submitted that the private by virtue of the said vacancy notification, one person has already been given offer letter. Full stop. By virtue of the offer letter, the person selected has already deposited the amount of money as required, but the order of conversion is outed. License has not been granted yet in respect of the vacancy notification. এটা নোট করো দিয়ে এবার কি order? Okay, call the matter.
Gratefully, lordships.
Well, your lordship
Yes.
has directed not to dealing the ration cards. You will pass the order, simply order not to dealing the ration card.
Not to pass, same order, not to give license.
That
Same
means not to dealing also.
Not to give the license.
Well, study I have submitted for lordship, my lord. Paragraph 9 and 10. That is, respondent number 5 has been selected on the basis of second inquiry report, my lord. Your lordship's pleasure was to direct the state to have information whether the license has been issued or not.
Yes.
May I apprise your lordship? Minute. So for the minute the participation is concerned, there as long as 10 number of participants was there, the petitioner herein, Utpal De, obtained the marks 51. The Gopinath Bera is the successful candidate herein. He got the marks 71. The Prosengi Dijana is the second highest candidate over here. He got 67. So, Millet, we have selected the highest number, the private respondent herein, and the private respondent herein has Millet, the offer letter has already been given to him. He has deposited the money. We will be issuing the license.
This is the status.
This is the status.
So submit the report. What prevent you submit the report?
I thought
But
initially
these things have to be incorporated in the report with the inquiry report and other. But by this time, they should be restrained from giving license.
no, certainly not.
No,
Certainly
no.
not. Certainly not.
by
A
specific-
person concerned who is unsuccessful, he is not coming under the zone of the consideration, not the second highest mark. He is the third highest mark getter. He is stalling the proceedings. And the highest mark getter has not been served.
No, that is, I have sought for the dispensation of Rule 26, my lord. And that's why, my lord, I have come to your lordship that there is urgency, they are going to grant license. And on the basis of second inquiry, they have taken this decision. This is my specific case, which they cannot do.
Millet, this has been dealt with the Millet so many cases by the Millet, the division bench. I just placed some of the Millet, the important Millet, the judgment over here. Which is Millet just.
Your lordship will kindly appreciate that when there is no affidavit, there is no the averment made in the plaint will have to be accepted in toto. And it is my specific submission.
I will file the report. In the event, he is not entitled to get any interim order. The person concerned who is the highest number getter or the highest the number holder, he is not being served without hearing him. How can
served? No. The interest has not been created up.
Correct.
Unless you give in the license.
Yes.
License today, kindly consider the person concerned who is the successful candidate herein, he got 71. The second number is the 67. My learned friend client is coming on the third row who got 57. Let
him place all the inquiry reports. Only second inquiry has been done. This is the only point.
The second inquiry, lordship knows the judgment.
If necessary, second inquiry can be
this
done.
Can be done.
In respect of all the persons.
Yes. So in that event, the proceedings cannot be stalled. We will issue the license. Where is the malafidness, my lord? We have not done anything arbitrary.
Malafide is that second inquiry has been done only to accommodate that person.
In that event, I have to controvert this one.
Yeah, let him controvert. But by this time, he cannot.
And the person concerned to whom this allegation has been leveled against, he also have the right to controvert the same.
He will come. I will serve him.
In the meantime, he cannot.
Very good.
By this time, when the plaint which has been.
Okay.
The state, my lord will appreciate the statement.
No. Who is the person?
Yes, my lord.
May I just
five.
Item number private S1 of 5.
5, my
Yes. Have you served?
My lord, I have asked for the dispensation of Rule 26.
However,
with leave of your lordship, I have filed this petition.
I understand. But the situation is the state has said that offer letter has been issued.
No, but license has not been issued.
Very well, you serve.
I will serve. But in the meantime, license should not be issued.
This cannot be go on.
Why not cannot?
But he has a person concerned who is become successful without hearing him, his right will be cut down. And the allegation will be go on uncontroverted manner.
State is the main party.
State is main party. You are saying he is the blue-eyed boy.
Okay,
he has to prove that.
Just I have heard it. I have considered.
I know, my lord, lordship. Always consider.
Mr. Sengupta.
You don't have to raise the voice.
We just raise this fire to be life.
Okay, you serve upon respondent number 4.
My lord, 5.
Respondent number 5.
My lord.
And the matter shall appear on 14.
In the meantime, license should not be granted.
No, cannot be.
At least up to
not at the BS 16. Not at the desire of Mr. Agarwal. This cannot be.
That is my.
If something happened, Mr. Agarwal can establish that this has been done on a malafide manner. Lordship will set aside the same. But in the meantime, without hearing the opportunity of the private respondent, the interim order cannot be granted.
Okay.
My lord will appreciate, my lord, that I am again beseeching your lordship, my lord. What I have stated in my petition, that has to be accepted in toto until there is an adverse report.
I understand.
So on the allegations that he has been favored, the offer letter will be issued. But license has not yet been issued. Before that, that's why I have come to your lordship to move this petition seeking dispensation of Rule 26. And your lordship has granted it. Now it is a time that at least up to 16th, license should not be issued. Heaven will not fall within 2 weeks. When the license not been issued in respect of the vacancy, which was published in the year, apparently she had this vacancy was published.
Okay, very well, I have heard. Please take down.
2024.
Okay, Mr. Agarwal, I have heard. Mr. Shumon Sengupta, learned counsel, appearing on behalf of the state, submit that the respondent number 5 had scored the highest mark in the selection procedure according to the notification of the state, wherein the devised marking system has been followed by the concerned appointing authority. Full stop. He submits that without hearing respondent number 5, no interim order can be passed. However, Mr. Sengupta also wish to use the affidavit in opposition against the writ petition.
Well, the offer letter has already been issued to him.
Yes, I have passed the order. Mr. Agarwal, learned senior counsel, appearing on behalf of the petitioner, submits that though offer letter has been issued in favor of the private respondent of 5, no license has been granted. Thus, till the license be granted, there must have an interim order. Having heard the learned counsel for the parties, it appears that the offer letter has been issued in favor of the respondent number 5, that ipso facto consider that ipso facto approves the consideration of the state, that state has selected the private respondent of 5 for giving him a license. Considering the same, respondent number 5 is required to be heard in this matter before disposing of the instant writ petition. Accordingly, the petition is directed to serve respondent number 5. However, as the license has not been granted, let there be an order of status quo till July 15th. 14th.
14 is placing.
15th.
Yes.
2025.
Lordship is stalling the proceedings.
Yes, for not giving the license till 15th.
Well, only simply based on the averment made by the Mr. Agarwal, Lordship is stalling these proceedings.
I have taken your submission also that you have issued the offer letter.
I have issued the offer letter, but the allegation which has been labeled against me, I have not got a chance to controvert the same and to place the Lordship. Where is the no in
place the affidavit then?
Only
Only 15. Till only 15.
But Lordship is passing. Lordship knows me far better than I do, and I unnecessarily do not argue before your Lordship. I do not, which is against my characteristics. Today, Lordship is passing an order without hearing a person who is become the successful candidate. Is it justified? I'm asking myself. If I go by the 3 principles of the interim order granted, this whether
so only till 15th, why you are so agreed? Come on 15th. Only I shall hear it out and dispose of the matter.
Very well.
You count affidavit on that date. Unless you filing affidavit, you can file the report.
I will be coming up. I will be definitely coming up.
I can fix the matter next week. As I am not there, that's why.
Lordship will not be there.
Yes, that's why I am fixing the matter.
For a long period, this proceeding would be stalled. That is the whole difficulty.
I understand this is the situation.
Lordship may.
Unless I can hear it out tomorrow.
May I just propose one thing? Let it be abide by the result of the writ petition instead of the Miller status quo. Abide by the result of the writ petition. If today
declared in May 2024.
Mr. Agarwal, I cannot raise the voice. I am not very well.
Yes, that's why not easy.
Lordship may pass the order subject to the result of the abide by the result of the writ petition only, instead of the filing of the status, instead of the passing of the status quo. It will be giving the same effect. If your Lordship sees there is arbitrariness, then Lordship would set aside the entire things.
Yes, I will pass the order.
Otherwise, Lordship has passed the status quo. In that event, the effect is that
only till 15th, not earlier that. I cannot extend this order on report, on your report. I'm not.
I know that, but dear Lord,
submit a report on that.
I understand.
You come.
It's not a question of bargaining.
15.
My lord, he will file within 2 weeks.
15.
Exception to
Report within 15. Next. Okay, this matter 32.
Number 32, my lord.
Yes.
The compliance report, my lord. The contempt are already present, my lord. DM and ADM, my lord.
Item number 32 is the 32.
My lord, 32 is only with regard to, my lord, the compliance of, my lord, Mr. Justice Tandon's order for joint inspection. My lord, let them, my lord, do the joint inspection. That is my sum and substance of my allegation. My lord, they have not done so, my lord. Page 22 of my contempt petition.
In fact, my lord,
what is the order?
My lord, order is, my lord, page 22, my lord, the operating portion, if your lordship kindly comes.
What joint inspection?
Joint inspection with Milord the state of Orissa, Milord, for Milord determining Milord the area which I have been allotted, Milord.
You have allotted what?
Milord, I have allotted Milord mining block for mining operation.
Mining block.
Yes.
So what is the direction?
The direction at page 22, Lordship. Kindly see the second paragraph. Accordingly, the court directs
Yes.
the state of West Bengal through its appropriate agencies to cause a joint inspection of the site in question along with the representative of the petitioner, and report shall be filed by the respondent number 4 in the form of an affidavit stating the outcome of the said joint inspection and the report submitted by the inspecting authorities. It is open to the state of West Bengal to inform the competent authority of state of Orissa to be a part of such joint inspection so that the land or site in question, whether falls within the state of West Bengal or Orissa, can be resolved. Now, Milord, this order was passed long ago, Milord, 23rd of August 2018. Thereafter, Milord, they preferred an appeal and appeal dismissed, Milord.
Very good.
Affirming, Milord, this judgment.
Yes.
Now, Milord, if your Lordship, Milord, kindly, Milord, this is only for compliance, nothing else.
Lordship, in this regard, Milord, the two state is concerned according to the boundary, the demarcation of that area. Not only that, after successful of the bidder, that amount already not yet deposited by the petitioner.
That Milord point already, Milord,
earnest
decided,
money.
Milord, by the
So
Honorable
it is
Division.
the
Just
by
wait,
the
let me hear
objection.
it out. I cannot hear both of you altogether. So what is your submission?
Lordship, the
Earnest money has
only simple order for the joint verification, that
Joint inspection.
joint inspection, that inspection is concerned in the two states, Orissa and Bengal, Milord. It is the technically problem. Not only that, after successful of the bidder, the earnest money not yet deposited by the petitioner.
No, that is not the matter before me now. Okay. So only before me is the direction of the Justice Horis Tandon. So whether is it possible to carry out the order for you?
Lord,
Joint inspection has to be done by the state of West Bengal along with the state of Orissa in presence of the petition. This is the direction. So what is your contention now?
It will take time, Milord, because
So what time you want?
more or less 3 months.
Milord,
Only the two state is concerned, Milord. Orissa and Bengal.
Have you written any letter to the state of Orissa or Bengal, whether you have taken any steps to clarify your position of the order or taking initiatives to so that that can be adjusted?
Letter already issued, Milord.
Letter issued. So you take you file it, you issue a reminder.
Not already reminder.
Reminder issued, but what is the outcome? What is the outcome now?
At this stage,
That
not
can be
yet
stalled like that. You have to take appropriate steps. I know the situation. Being a contemptor, that is the additional district magistrate or district magistrate, is not possible for him only to inspect because it is a joint inspection. Both the parties.
Not to kindly grant a suitable time, Milord, thereafter inform.
So the petitioner has to be there to accommodate them. Otherwise, how
Milord,
can
I have not been called for even. Milord, I do not know when
the
they have.
situation is otherwise. This is not a properly contempt is not upon the only alleged contemptor to be
Milord,
done.
since Milord, the state
Joint
of
inspection
Orissa,
is required
my
to be
Lord,
done.
I
The
understand.
state of Orissa and their persons has to be there to
But
conduct the
Milord, Lordship,
inspection.
kindly let them show, Milord, when they have intimated the state of Orissa. Because Milord, 2018, long ago, 7 years back, this order was
Forget
passed.
about that. They ask for 3 months. Let them proceed within 3 months.
Milord, 3 months would be, Milord, my humble submission. Milord, now, Milord,
Situation of the Mednipur, Milord. The
Milord,
DMs are
already,
totally busy, Milord. At this stage, Milord, pay for 3 months.
Milord, for that, Milord, my client has to wait. Lordship, kindly sees, Milord,
during
in
the
the
month
earlier occasion, Milord, when this Milord, when this notice was issued, they didn't appear. Now, Milord, they are taking the plea, Milord, 3 months. Milord, Lordship, kindly make it, Milord, 1 month. Milord, put them on terms.
No, feasibly possible within 1 month. What you are saying?
Milord,
Within 1
Milord,
month,
intimating.
they will serve a letter there would be some
Milord-
consent, there would be a date, it
Now,
would be
Milord, they-
communicated to you. Thereafter, the
Milord,
constitutional inspection can be
Milord,
done.
now, Milord, the emails are, Milord,
Emails are
communicated to.
possible. Emails is there.
Milord, I'm sure,
but
Milord, the state of
there
Odisha will
must
not
be a
come
date.
into way.
There must be a particular date which has to be communicated to you. You have to be there. Otherwise, that is not possible.
Then Lordship kindly make it 6 weeks or 8 weeks. Milord, 3 months would be, Milord, much. Milord, 3 months, Milord, the puja will intervene and all these things, Milord, will happen.
Very well.
Lordship, during the monsoon period, Milord, it is not possible for joint inspection, Milord.
You take at least steps so that I can. September 16th, I am fixing a next date. Within the meantime, you take appropriate steps for causing joint inspection. Okay.
Grateful.
Please take down.
Personal appearance.
Personal appearance differently.
Personal appearance of alleged contemner. That is
Contemners.
alleged
3 and 4, Lord.
contemners. Who are the alleged contemners?
Milord, 3 and 4, Milord. The district magistrate is 3 and 4 is, Milord, the ADM.
Alleged contemners.
Here, Milord, 1 and 2. Milord, contempt cause title 1 and 2. 1 is, Milord, the district magistrate and 2 is, Milord, the ADM. ADM LR.
Bolo.
Yeah, copy আছে।
Alleged contemners, namely Khurshid Ali Kadri, district magistrate Paschim Mednipur, and Suman Saurav Mohanty, the learned, the additional district magistrate LR, personally appears before this court. Having noted their personal appearance, their further personal appearance is dispensed with. Full stop. Next paragraph. Affidavit of appearance of the alleged contemner is accepted. Full stop. Next paragraph. It appears that by virtue of impugn order dated 23rd of August 2018, a coordinate bench of this court has directed the respondent number 4, that is the alleged contempt number 1.
Lordship.
1.
Respondent number 4 is alleged contempt number 2.
Alleged contempt number 2.
And
alleged contempt.
P is, Milord, 1.
Okay. Alleged contempt number 2. To cause a joint inspection of the site in question, along with the representative of the petitioner, after informing the concerned official of the state of Odisha. Full stop. Learned counsel appearing on behalf of the alleged contemner submits that the alleged contemner in their official capacity had issued the appropriate letter to the authority of state of Odisha, intimating the order of this court, and several reminders has already been issued. But no assertion from the state of Odisha has ever been reached. That's why that is the reason the joint inspection could not be done. Full stop. Learned counsel appearing on behalf of the petitioner submits that the impugn order was passed in the month of August 2018. Since then, the petitioner is suffering for want of joint inspection. Having heard the parties, it appears to me that this court has directed that a joint inspection to be done in presence of the petitioner with the officials of state of West Bengal as well as the authority of state of Odisha.
And the before inspection, if any dues amount.
No, Milord, that is not the
That
condition.
is not now.
Milord, now my learned senior is
not
taking
in
this.
my jurisdiction or to look into the matter right now. let you take appropriate steps according to the order. You can prefer anything against that if he is not ready to filing any money or like that. Very well. Odisha. I can understand the situation that both the state of West, both the officials of both the state has to be consented to a particular date for causing joint inspection. At this situation, the learned counsel for the petition, learned counsel for the joint contempt seeks some time to comply the order. Petitioner raised strong objection. Having heard the parties, I think it necessary to direct the alleged contemner to comply the order of this court, order of the coordinating bench of this court dated 23rd of August 2018 on or before 16th of September 2025. Let a compliance report be placed before this court on the said date. Please the matter on 17th of September 2025.
Grateful one. Develop.
Yes.
And for the private respondent, led by Mr.
Like, Milord, may I pray for only one thing?
1 week.
May I pray for only one thing?
Yes.
Would your lordship show some kindness, at least in this matter, towards me by dismissing the matter for dismiss for default?
Dismiss so far this matter is concerned, license has been granted, allotment has also been made in my favor.
Everything.
So who is the petitioner?
Mr. Dhara.
Where is Mr. Dhara?
That is why I am saying lordship is kind enough to pass the order in favor of the petitioner as always. So today, Milord, I am praying for dismissal. At least show some kindness to the Milord, the respondents.
You have filed the report.
Yes.
Everything is ready.
Everything is ready. There is no arbitrariness. Mr. Dhara's client is not coming within the zone of consideration. The license has been issued.
Allotment has been made.
Everything has been going on.
Let me see your report first.
Certainly, Milord. The report.
Yeah.
So Mr. Dhara's client name Maloti Ghosh.
Yes. If your lordship kindly take trouble to see paragraph 4, I have Milord pointed out why candidature of Mr. Dhara has been rejected.
Paragraph 4, yes.
Paragraph. I submit that the storage facility of the respondent number 6 in the instant writ petition was found to be larger than that of the petitioner, making it more suitable for the FPS operation. This is point number 1. It is stated that the shop cum godown proposed by the respondent number 6 consists of a covered concrete veranda and 15 feet approach road with the appropriate parking space for loading and unloading of the goods. Moreover, the respondent number 6 also duly recommended by the district level such and such. And the paragraph 7.
Yes.
Accordingly, the provision of the chapter 3 clause 12I of the WBT such and such, an individual cannot obtain a dealer's or distributor or license if they or any of their relative already hold such license, whether in their own name or as a partner or as a member of a self-help group, Shangho, such and such. In this regard, it is stated that the petitioner's daughter is already holding an FPS leadership.
Petitioner's daughter?
Yes.
Okay.
And also kindly consider paragraph 5. The petitioner does not reside in the same Gram Panchayat where the FPS is to be allocated. On the contrary, the private respondent seeks is the resident of the concerned area, which is the key consideration of the selection process.
However, the private respondent 6 was allotted more numbers.
Yes.
Highest number.
Highest numbers.
And what is the status now? Have you stated this?
Yes, they are running. They are continuing with the distributions.
In my paper, I am running this by my paper.
Have you stated this in the affidavit?
Yes, yes.
In your affidavit, have you stated
কোথায় বলেছি যে ওর যে
license was granted or not?
Just give me a moment.
Yes. No, he has admitted the license has granted.
Yes, that is initially
Admitted.
admitted.
Not necessary. Okay.
They have also filed our affidavit document. Would like to get no denials for our statement made in paragraph 4.
Hey, people. এটাই কিন্তু সেটা এটাই সেটা হ্যাঁ এটাই সেটা Milord, Lordship may recall, initially I have made a submission that the license was issued. After that, I have pointed out that was a wrong submission made by me
Yes.
because there is another set of litigation by which Lordship has passed on status quo not to give the effect or not to give the license in favor of the petitioner, the curtailment of the Milord the things.
Okay.
Lordship may recall that is possibly standing in the way till date. হ্যাঁ পিঙ্গল না জেনে কথা বলছে দুম করে
I have now heard Mr. Sengupta said, if license has been granted, petition should be dismissed.
Did I say so?
Yes.
Oh, okay.
Nasib, don't take the matter.
Don't take the matter, মানে?
Nasib,
কি বলছিস তুই?
Nasib, adjourn this matter because I am received a call from my client. He did not want to proceed with the writ petition, but later not yet received by me. So, kindly adjourn the matter. I can.
বল যে আমি সিলভার টনিকটা পাইনি। That is the main crux of the matter. বল সেটা। এই জন্য করছিস। কালকে টুপি মেনশনে রেখে দে।
কালকে আমি আসবো না।
So everything is ready. That the matter can be disposed of today also.
No, my lord, my client don't want to proceed with the writ petition.
That is very well. I am passing the order.
But my lord, I am not
On
received
recording
the
your
letter.
submission.
No, my lord, I am not received the letter, my lord.
Or I can pass the order in merit. On merit, I can pass.
No, merit, I can proceed with the matter.
You can proceed with this matter.
No, because my client instructed me.
So come on tomorrow.
But I am not come.
Day after tomorrow.
Day after tomorrow.
This matter appears day after tomorrow to be made.
Yes, at first.
Lordship will not be here from the next week, I guess. That's all.
Day after tomorrow is the only option.
আজকে না না আমি থাকবো না অমিতা ঠিক আছে
তোমার নাম দিয়ে
I have no difficulty. Whenever your lordship
If you want to pass the order on merit, then I can pass the order.
Beloved, I initially indicated I know the kindness of your lordship whenever lordship is passed, sitting over here, passing the order in favor of the petitioners. I am not being graced by your lordship in any of the occasions.
You have graced?
Not being graced by your lordship.
Graced, I can remember.
No.
I can
Not
remember.
even, my lord. This is very,
very
Beloved, I am not being graced by your lordship, a kindness which should be fallen from your lordship, not for a single time, my lord.
Is it?
Yes. Not even a rule I was praying for lordship may recall that was being rejected by your lordship, despite that university matter, my lord. Whenever nobody is appearing, lordship has not issued the rule. Lordship shows so greatness.
তুমি তো বৃহস্পতিবার এটা বন্ধ করতে পারবে না এটা বন্ধ করতে পারবে না স্টপ দিস কেন হবে না স্টপ দিস সার্কুলেশন স্টপ দিস সার্কুলেশন
এটাকে বন্ধ করে দিই হ্যাঁ
Next week, not this week. Not this week.
Yes.
Not this week means after 14.
2 weeks time.
Item 25, Lord. Item 26, Lordship. My landed senior is mentioning item 26.
Yes, Mr. Laskar is Karar is also there.
Kindly.
Lordship, I've pushed the live stream, so that's why I was unable to answer, Lordship.
I can
Lordship,
understand your
in
argument.
earlier occasion,
I
when
can
the matter
understand
was
your
taken
argument.
up,
Generally, Milord, I do not. You lost my tip.
In the chamber, I have said my senior judge that this is the situation is running on there. The
Lordship,
students
may I
are
be
there, not
permitted
the
to
other
submit?
parties, not the employees or like that.
Exactly.
They're the mere students. I
Obliged.
know the entire fact of the appeal. I apprise him the entire fact of the appeal.
He was not. He was
And what
not.
is going on there?
Correct. Correct.
Since 2013, they are at the limbs of the.
Lordship, in item number 26, Lordship may recollect in earlier occasion there is a direction that some document has not submitted with the writ petition. So Lordship was pleased to direct us to file the document, Lordship. We have prepared a supplementary affidavit and we are about to file that, Lordship. May I, my junior is there, Lordship. I am directing to hand over a copy to the learned advocate appearing for the state, and the original copy may be taken on record, Lordship. For the proper adjudication of the case, Lordship, I have that in earlier occasion I have provided the acknowledgement of my application. Now, Lordship was in the view that the document should be provided. Now it has been provided, Lordship.
Supplementary affidavit
So
filed on
on
behalf
this
of the
very
state
next day,
taken on record.
Lordship, they will come and answer.
Copy served upon the learned counsel appearing on behalf of the state respondent. Let the matter
Lordship.
appear in the list 23rd of July 2025 under the same heading.
Grateful, dear Lordship. So, July, Lordship, grateful, Lordship.
এই আরেকটা কপি দিয়ে দিবি ওই
Your Lordship,
I am for the read petitioner.
I am for the private respondent, Your Lordship. Mr. Respondent Oil Company. Your Lordship, Mr. Ramanand Agarwal is appearing. He is not ready, Your Lordship. I'm beseeching Your Lordship kindly not.
Lord, I have completed my argument. Your Lordship was pleased to make it hard in part. There was a direction and a request by the Lord Appellate Court to conclude the matter within a certain time. And that period already over.
And it's an order, madam.
That period is already over.
The period is already over, madam. And it's a short date, madam. Page number 81, madam. Any day, Your Lordship, after returning from the circuit bench.
Because they have been enjoying the order.
Page number 81, madam, paragraph 5. Our executive document. Paragraph 5.
Order dated 25th of August 2022, passed by the division bench. Paragraph 5, it says the pleading shall be exchanged amongst the parties by the end of November 2022, and the Honorable Single Judge is requested to dispose of the matter within 3 months from 1st December 2022, subject to his Lordship's convenience, taking into consideration the pendency in the board. That's the situation, my lord. Now we are in the month of June 2025. Kindly fixes any short date, my lord. That would be my extreme prayer, because I cannot say that don't allow their prayer for adjournment.
So it is the desire that within March 2023, within 3 months of month of December,
yes.
December 2022, preferably March 2023.
Yes. We are in the month of June 2025.
How can it be? Very well. Yes.
Any day, Your Lordship, after.
Tell me a date. Tell me a date after 14th.
Because even on 5th of May, they paid for adjournment.
That's why I'm asking them.
Yes. Yes, ma'am. Let them keep it.
Your Lordship, 14th or 21.
14th, I am coming. 14th.
Then Your Lordship on 21 July.
21st July, one. That's a different day, my lord.
Then 22nd of July, Your Lordship.
15 a 2 p.m.
What is it?
ষোলো তারিখে বলছেন ঠিক আছে হয়ে আমি বলছি হ্যাঁ আজকে ট্রাই করছি 16 তারিখ 17 তারিখ14th of July 2025 at 2 p.m. An accommodation is sought for on behalf of the private respondent. Let the matter appear in the list on 14th of July 2025 at 2 p.m.
Great, Your Lordship.
Next.
For the private respondent.
Yes.
No, this is the read petition.
Whereby I have questioned the selection process and the selection of the private respondent and grant of delectip, my lord, in my favor. These are the three prayers, my lord, in the writ petition. My lord, I take your lordships to the advertisement itself. That's at page, my lord, 14 of the writ petition.
Yes.
My lord, dated 16th November 2022. I have probably shown to your lordships on the first occasion. Now, your lordships will find at page 14, clause 9. Last date of submitting application. The application can be submitted during working hours on any working day in the office as mentioned above or through online within 21 days from the date of publication of indicative advertisement of the FAC vacancy in the newspaper. So, my lord, this will dependent upon from the publication in the newspaper. This is one thing, your lordships. Now, second, your lordship, page 15. Kindly see clause 14 of this part 4 under the heading part 4.
Yes.
Page 15 under the heading part 4 clause 14. Documents to be attached. Documents to be attached. The applicant must submit the following copies or original supporting documents along with the application for in form C, all photocopies to be self-attested. Now your lordships will find all the documents asked for. Kindly turn over to the next page. Under the column, your lordships, Roman 7b.
Yes.
For lease oblique rented property, colon, registered lease deed or tenancy agreement with the copies of rent receipt for all the months from the date of agreement till the date of application, and registered deed oblique ROR in the name of the landowner for lessor. So therefore, my lord, if in case of lease, there must be a registered lease deed. Now, your lordships will find from this writ petition at page, your lordships, my lord, the document, my lord, submitted, page, I take your lordship, page 46. But it's not readable. If your lordships kindly take up in the petition, this document is not legible. If your lordship supplementary submit kora hoyeche to, your lordships for this document kindly take up the supplementary affidavit. Now your lordships kindly see lease agreement. This lease agreement is made at Raniganj on this day, 4th of February 2023, between Robu alias Robul and your lordships lessor and two Anikul Hawk lessee. Well, kindly see the first party is the father of the second party. Then your lordships kindly see the next part. This is, my lord, a lease agreement on notarized. Now, whereas the lessor is the owner and possessor in possession of the property, details described below. Then your lordships will find, whereas the lessee has expressed the lessor to give on lease, I don't know, the language is wrong probably, to give on lease the above mentioned scheduled land of consideration of rupees 24,000 per year, and the lessor agreed to give the same to the lessee under the following terms and conditions. The lessee will pay a sum of rupees 24,000 on the first day of signing this lease by cash.
Then, 2. The lease agreement will commence with effect from 1st February 2023 and the duration of the lease is for 25 years. So, what are the conditions? Lease for 25 years and annual rent, if I go by that, 24,000. Then your losses, it's from a period of 1st February 2023 to for 25 years. But this was signed your losses from 4th day of February. I will not argue on that. Now, after completion of the term of the lease and lease may be extended with consent. That's consent. The other two criteria of that. Now, your lordships kindly consider kindly consider your lordships the just a minute, your lordships. Kindly take up the report file before your lordships, then I will take. Report file with inquiry report, page 9.
Yes.
This is in regard to your lordships, the petitioner before your lordships, Nurul Islam. Now, your lordships will find in regard to this, page 60, page 11, column 65. The land of the proposed godown is located within the vacancy location and the godown and sales counter are suitable. Total area is more than 600 square feet at the time of inquiry, hence the application may be recommended. This is in regard to your lordships, Nurul Islam. Now, your lordships kindly consider then page, pagination. I think page 12 your lordship should be.
Yes.
Page 12. This is in respect of the private respondent. Well, kindly see. Last date of application, 6th February 2023. Date of this application, 6th February 2023. Well, I have taken to the lease agreement, unregistered lease agreement, that was executed on 4th February. Therefore, this application was made on the basis of unregistered lease agreement. So now your losses kindly consider next page, page 13. I don't know how this type of comments are made by the government officials. Column 26. Whether the applicant has submitted all documents as per checklist. Has you also got that one? Page 13. Kindly see. Whether the applicant has submitted all documents as per checklist. No. Audit return, unregistered lease agreement. Registered lease agreement. Sorry. No. That means report says he could not submit audit return and a registered lease agreement. That's the report. Page 13, column 26.
26.
Yes. Whether the applicant has submitted all documents as per checklist. No. But which of the documents are lacking? Audit return and registered lease agreement. So, I am pointing out this to your lordships that the authorities are conscious of that they are proceeding with an application which doesn't have any registered lease agreement. Even then, they are proceeding with that. Next, your lordships will find the recommend page 14, paragraph 57. Under the heading possession of the storage godown, rental possession, Sheikh Rabiul Robu, number and date of execution of the registered deed agreement. Kindly see your lordships. Tenancy notary, they have noted it. 4th February. Then period of lease tenancy under registered agreement, they did 25 years. Whether expressly rented or leased, yes. I don't know which one, which they are construing. Is it rented or is it leased out? Then you'll see whether ROR of the owner, I'm not going to the ROR, it's not requirement. Then your losses at the bottom, 65. The land of the proposed go down is located within the vacancy location, as recommendation have been made to me, the same recommendation. Now, on the basis of this paper, selection has been made. Kindly look at the selection, your lordships, at page 16. This the first time I have come to know. At the bottom, unequal hawk. Now, kindly see the column, marks for size of go down, 15. I think, my lord, out of 15, 15 has been given. Now, kindly see, I have been given 5. But my case is also that the other 2 persons who have been placed above me, they have the similar type of documents like the private respondent. Now, the persons who have the valid document, he has been given 5 out of 15. And the person who doesn't have, Lord, I don't know how they're explaining it, Lord, 15. When the deed itself is not acceptable, they're giving 15. Now, kindly see, Lord, the amendment made in regard to this. Page 7, paragraph 8. Thus, as per the details provided in online inquiry report, as you also got that one.
Yes.
Thus, as per the details provided in online inquiry report, as provided by order dated such and such, score sheet of all applicants were generated online for the total of 75 marks, and considering the marks obtained by the candidate and proximity with the central location, the most suitable candidate was recommended by SCFS. Thereafter, score of the remaining 20 was given by the district level fair soft selection committee. From the course sheet, it is clear that the dear recommended candidate Anikul Hawk has obtained 84 marks in total, and the incumbent has obtained, I don't know, the read petitioner should be, I know the income, 72 marks only. The main difference in marks between these 2 candidates, the size of sales counter and go down. Kindly have a look at this. How he has overlapped me. 15 marks versus 5 marks, category 10 marks versus 8 marks, and marks given by 14 marks versus 12 marks. The candidate has thus recommended. But this is not the answer. Answer was whether he is at all eligible under the terms and conditions of the advertisement. His application should not have been entertained.
Yes.
Now, this is my lord, the only point, your losses, this should not have begun. And so far, your losses, if you then I will take once.
During argument, they admitted that the agreement which they have placed is notarized agreement, not the registered.
Not.
So it is barred under section 105.
That's my point. And registration act, your losses. I have taken your losses. Kindly have a look at this. Just a minute, I'm giving to you losses. Page 2. But I have put a tick mark, section 17, 1D. Kindly excuse me, I put a tick mark. Documents of which registration is compulsory. Yes. And they wanted that, my lord. Advertisement says registered lease agreement. The documents shall be registered if the property to which they relate is situated within the district such and such. Not kindly see straightway I have given you also D. Leases of immovable property from year to year or for any term exceeding 1 year. 25 years, my lord. And exceeding a yearly rent.
Yes.
And now your lordships kindly consider, this is my my lord, affidavit in opposition of the private respondents. এটা কি register?
It was argued by the private respondent that the clause requiring the registered lease agreement is not mandatory. Number one. Number two, they have said that as they have the most spacious godown, and after that the place, that is the godown, was transferred in favor of the.
Now this is now the, my lord, I'm sorry, ball is now before your lordships. Whether the registered document is registered or necessary, my lord, kindly see the 1 second. Then my lord, my job is very, my lord, very little and short. Kindly read the agreement, your lordships. My lord, advertisement. I have placed before lordships, page 15 and 16. এটা একটা ভালো কপি আছে কোথায় দেখো এটা আসল ডকুমেন্টস গুলো কেন এরকম হয় আমি বুঝতে পারিনি এটা কিসে আছে exception to the report. My lord, for the legible documents, if your lordships kindly come to the exception to the report. It's at page 13, 14, 15 of the 16 read petition. It is little better than the earlier one.
No, I can read it. My copy is good.
Now your lordships will find what I find. In case of ownership, probably your lordships at the top. In case of ownership slash, my lord, slash we read, my lord, or. Shared ownership. A photocopy of the record of rights slash registered deed of conveyance slash purchase gift in the name of the applicant. B. Documents showing character of land as other document commercial bastu if record of rights is not produced. C. Up to date property tax receipt and NOC from other co-owners in case of shared ownership of the offered palm swap come go down. B. For lease oblique rented property, colon, registered deed of lease or tenancy. Well, there are two different, absolutely different things. In case of ownership, record of rights is material. That's because he is the owner himself, he or she. But when you are not owner, you got a land for application purpose by way of lease, then that must be a registered lease deed. Then everything goes. Now, if your lordships can put a question to me, probably my junior says your lordships from, and now the question is, I'm 5. How do I come? No, my lord, had I known that unregistered lease deed could have been applied for, then I could have shown, my lord, much bigger land. That's not the condition either. And I don't know how you have proceeded with the others also. When you proceed with a person selectively like this, then you have proceeded with the others also. So the whole process should be cancelled. It's not that I have to be given alone.
Private respondent has placed 2 decisions.
Yes, your
that is 1995 1 SCC.
95 1 SCC.
1 SCC 133. That is the term shall is ordinary mandatory, but in some case it is not so mandatory.
Now we'll also decide that in case of lease, property doesn't go, Malak, then we have to, Malak, go to the law school now. Now your losses can take up the, Malak, the transfer of property. This is, then we have to go to, Malak, the law. Malak, kindly see 105.
Yes.
As your losses was referred to that. Malak, section 105, if your losses kindly take up once. No. No. What is lease, your losses kindly?
Yes.
A lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration of a price paid or promised, or of money, share of crops, service, or any other thing of value to be rendered periodically or on specified occasions to the transferor by the transferee who accept the transfers for such terms.
Yes.
So therefore, my lord, for the pinpoint your is transfer of right to enjoy. So unless if it is not mandatory, he doesn't have the land even on lease. How could he apply for that? You cannot apply, my lord, judgment just my lord, on the my lord, has to be shown, that should not be shown only, my lord, just whether one has to consider whether it is, my lord, fit in the case of the fact before citing a judgment. In case of lease is a transfer of a right to enjoy such property, then you have no right to enjoy the property. It's obviously mandatory. So that's my submission, Your Lordship.
Huh? My lord, in earlier occasion, my senior already submit on the point of lease agreement. On the lease agreement, I will submit the written argument on this point.
Lordship, written notes of argument.
Yes. No. This one already opposition already given. Replies.
Written notes of argument.
Notes of arguments. Written notes of argument.
Reply. Put in the form of.
I'm going to copy them.
You
My
serve
lord-
copy.
Yes, I serve. My lord,
No, right.
my lord, I want to submit.
Why?
My lord,
The argument conclude.
my,
Reply in
on-
our-
only my lord. Now, according to me, my lord, the writ petition is not law custody, my lord. Only I want to say some point, my lord. According to the notification, my lord, part 4 of subpara 7D, my lord, if the registered deed or co-owners, the shareholder must be submit no objection certificate of the co-owners, but the petitioner did not submit the no objection certificate for the co-owners, my lord. According to the notification, my lord, in para 4, subpara 7D. Next point is the godown is of the petitioner, my lord, are 50% in wasteland. And and the petitioner, my lord, at the time of submit application, he has no conversation the remaining land, my lord. And the petitioner is the third position, not in the second position.
Okay, I have heard that. Not necessary to argue further, okay?
Lord, only one thing, your lordships, if certain points not taken in the affidavit in opposition, written statement arguments, they should not, unless it is purely question of law.
Yes.
Factually, they should not.
In opposition, I have taken this. I already taken in my opposition.
Very good. Okay, I will take up the matter. Please take down. Argument on behalf of the parties concluded. Made seal.
Grateful.
टीवी कर लो
Give me Xerox copy of these.
আমাদের নেতা নেতা এরকম এখানে রেখে গৌতম দা গৌতম এরকম বুঝলি তো
Who is for the state? Okay.
Consider the order passed by your lordship on 10th of February 2025. Prima facie holding that the writ is maintainable, since that was the argument advanced on behalf of the respondents, private respondents.
The private respondent said.
স্টেট অ্যাডমিট করে নিয়েছে কোনো স্যাংশন প্ল্যান নেই
But if they have preferred an appeal, they have said on the earlier occasion.
For last 6 months, this is going on. No copy has been served upon us.
No copy, sir.
We don't know what is the number even of the appeal. The
So,
simple
no,
point involved in this matter is, my lord, in a bus jar, MR distributor's business
I
has,
understand. I understand.
and the state has affirmed and report saying accepting our views. Till today, there is no classification, change of classification.
So
Till
report
today,
place.
this appears as a bus jar. No sanction plan. These are the only point. So only recourse of the private respondents to take the point of maintainability.
Okay, let's start argument. Otherwise, it cannot be started like that. Where is the private respondent?
He was there. His junior, friend to my junior. That's all legal. Okay. Just one paragraph, if you lordship kindly take up the report filed by the state. Paragraph 14, page 6 onwards. Report filed by the state.
Yes.
On the scheduled date of inspection, the chairman of National So-and-so, that is the private respondent, was present. In his presence, the proposed godown and the cell counter has been measured by the inquiring official. All the relevant documents were also verified accordingly. Additional District Controller Food and Supplies Murshidabad submitted the detailed report on so-and-so along with the necessary documents. The inquiry report along with the necessary documents was forwarded to the Deputy Director so-and-so. Then kindly turn the next page. Paragraph 17. That in pursuance of the order so-and-so of the Honorable High Court, paragraph 17, in the matter of Captain so-and-so, hearing of petition was taken in presence of the Director, District Distribution, Procurement and Supply. After the scheduled interim order was passed by the Director DDBS on so-and-so, and the said order was communicated so-and-so, told him so-and-so, Morebat lay final. On 6 January 2023, presence of the Director. Then kindly turn the page, my lord. Second paragraph, last 4 line. Sentence starts. The middle portion from second paragraph. The petitioner can be considered in getting a license MRT distributor, except the fact that the present godown is not at all fit to accommodate the huge quantity of food grains that a distributor has stored. Thus, the petitioner is asked to upgrade the godown. This is one of the point. Then kindly turn the page, paragraph 9, page 9, paragraph 20.
No, what is the order? This is the order. Whose order?
Your
This
Lordship,
portion?
I'm going through the report filed by the state.
No, I understand. You are reading
No.
paragraph 8.
Well, an order has been passed by the director, allowing them extra time, additional time. Then even if you kindly turn to paragraph 20, page 9, that has not been done. The pending adjudication of the objection approval has been granting in favor of the private respondent number 6, where no sanction plan has been granted by the Murshidabad Jilla Parishad. This is the admission of the state. And in the opposition, if you kindly take up filed by the private respondent, one paragraph, paragraph 7, Roman 13, page 15. One paragraph, page 15.
Affidavit in opposition by the respondent number 6.
My lord. Page 15, paragraph Roman 13. Paragraph 7, Roman 13. It is stated that on 1st February 2023, the director TTPS directed the private respondent hearing to upgrade its godown in terms of the relevant provision of national so-and-so within a period of 4 months from date. It is further stated that in the month of June so-and-so, the answering respondent hearing had upgraded the godown so-and-so. No normal license was fully answered. Then paragraph, next paragraph. It is stated that the private respondent duly sought for sanction from the appropriate authority for the upgraded portion of the godown. Right, so-and-so. But this is has been affirmed. Kindly see the page of affirmation. After filing the petition, they have applied for. And then for page 45, the document. This is the lease date, page 45, 17th August 2023. Kindly turn to page 62.
This is the lease deed in favor of the private respondent.
My lord. Page 62, kindly turn up. Page 79 also. Page 48, denotes my lord, page 48.
Two lease deeds.
Two lease deeds. Their admission is there, both by the state and the private respondent. That no sanction plan, land has been classified at Doba. Basjar, sorry.
In the schedule, it is stated that it is VT.
It's what.
Okay.
So, Procedural, since we are praying for adjournment.
Milord, I appear for the Milord private respondent. Milord, we have preferred an appeal. Milord, it is likely to be listed within this week. Milord, under such circumstances, if your lordship would kindly adjourn this matter. The matter was mentioned today before the Honorable Division Bench for Milord listing, Milord. I will serve notice upon my learned friend, Milord.
You serve notice to them.
They
They are
have
not.
served the copy of the appeal. I have the affidavit of service, Milord. It is there, Milord. Copy has been served upon the office of the learned government pleader. State has received, and upon the petitioner, Milord Faizul Haq, White Speed Post on Milord 27th of February 2025. Duly delivered to the addressee.
Very good.
And the petitioner is aware of the pendency of the appeal.
আসলে মামলাটা করে দেন আর কি মানসার করছে কষ্ট করাবো
August 1st week. Let the matter
Kindly
appear.
record something. July, end of July, my lord.
I don't
End of
think
July.
that it Q2G Miller heavy list will it won't be possible.
Heavily. The entire matter has been called for today. I did 2 cases.
Item 15 is going on before Justice Miller.
Group A তে কতগুলো matter আছে? 3টে matter ছিল। There are only 3 matters group 8.
Very well, 4th of August. Let the matter appear in the list on 4th of August
Now
2020.
kindly record something, my lord. So far the appeal is concerned.
Okay. What is the number of appeal?
It is MAT 281 of 2025.
Learned counsel appearing on behalf of the petitioner submits that.
Private respondent.
Private respondent. Learned counsel for the private respondent submits that the private respondent have preferred an appeal before the Honorable Division Bench against the order passed by this court dated
10th of February
10th February 2025, being MAT number
281 of 2025.
281 of 2025. He further submits that the matter was mentioned before the Honorable Division Bench for listing. Concerning the submission, the matter be adjourned today. List the matter.
Now, it was also the submission that it is presumed matter will be taken up this week.
Okay.
Mentioning was allowed, my lord?
Okay. It is further submitted by the learned counsel for the petitioner that for the respondent, private respondent, that matter shall be taken up by the learned division bench within this week. Concerning the submission, the matter be adjourned to release the matter on 4th of August 2025.
I'm getting me. The same position.
2 p.m. Same position.
2 p.m. But since your lordship heard this matter, can it be heard in part, my lord? Because I have almost concluded my submission.
Let them come.
My
On the 4th, I will have.
At 2 p.m. my lord.
2 p.m.
ঠিক আছে
না এটা আমাদের
So my learned friend starts in this matter. We have filed an application under section 340 of the CRPC. That so far the forged document is concerned, but your lordship desire was the entire matter will be heard. Let my learned friend start.
Yes.
The father of the petitioner was appointed as a fair price of kerosene oil dealer at Katna PS Boroa in the district of Murshidabad, my lord, under Gandhi subdivision. My lord, when he was in old age condition, one matter was moved by my learned friend kind.
Petitioner is a fair price of dealer.
It is not petitioner, the father of the petitioner.
Father of the petitioner.
Petitioner. But when he was alive, at the relevant point of time, a petition was moved by one of the son of the said fair price of owner. And obtain an order. That is annexed P1.
So erstwhile dealer was Abdul Mukhtar.
My lord. The first petition was moved by my brother, but the petitioner's brother. Namely Muhammad Samsul Kobir. first writ petition was moved.
First writ petition filed by one of the son of the erstwhile lemma dealer.
My lord, who is the brother of the petitioner herein?
Page 21.
Page 21.
Abdul Mukhtar was also the party?
Yes, Abdul Mukhtar was also the party in the said writ petition and obtained an order. My lord, my client, that is the petitioner.
Where is
here.
the order?
Order. Start from page 21, my lord.
Page
23 starts.
Yes.
The petition number 1 is the fair price of from kerosene oil dealer. He prays for inclusion. Petition number 1. Inclusion of the name of his youngest son as partner in the fair price of SK oil dealerships on account of his physical incapacitation. According to the petitioner, the same is permissible in view of the amendment incorporated in the West Bengal, etc. One has submitted a representation before the subdivisional controller and alleges that the same has not been considered till date, as it appears that the representation filed the petitioner is pending consideration. At the end of the respondent number 4, accordingly, the instant writ petition is disposed of by directing the respondent number 4 to consider and dispose of the representation filed by the petitioner on 13th December 2021. Strictly in accordance with said respondent shall pass a reasoned order. The petitioner is directed to forward a copy of the representation dated 13th December 2021 and the writ petition and disposed of. This order has been obtained. And the petitioner before your lordships was not party in the said writ petition.
Yes.
And as such, he filed an appeal, filed leave to appeal along with stay petition, memo of appeal, etc. And obtained order, that is page 25, annexure P2. Page 25, it starts, my lord. On behalf of the appellant, Mr. Cherry Lanek appears and presents the application for condonation of dolly, etc. Had the parties caused on for condonation of delay is found sufficient, delay stands accordingly condoned. The appeal along with its other connected application and respective efficacy of operation of the order impugned for leave to appeal stand accordingly regularized and are accordingly brought on board. Thereafter, the point, Mr. Cherry pointed that the writ petition was filed by his father and one of his brothers. It has been intelligently disposed of by the honorable single bench with a direction, etc. Mr. Cherry submits the next sub-conclusion to a partnership by inducting the writ petition to there is other son and brother of the present appellant as partners. The prayer for reconstituting the partnership is violative of the provision of clause 20E of the amended public distribution system, order 2000, etc. It is submitted that the license can be converted into a partnership only if the family members proposed to be inducted or substituted as a partner is there without a regular means of income. But in my opinion, he has the regular means of income, so he cannot be. We submit that the writ petition number 2 is in this appeal has a regular source of income and such requires to be brought to the notice of the concerned subdivisional controller. It is further submitted that the deed of partnership is doubtful inasmuch as there are discrepancies connected to the age of the writ petition number 1 of the father, appellant pays for leave to file this appeal, and on the appeal being adjudicated, a right of hearing before the concerned subdivisional controller. Next page, my lord. Both the sir, yes, appearing for the writ petition number 1 and 2, appeal and Mr. Sengupta, etc. Section 20E of the amended controller and submit that a legal duty is cast upon the subdivisional controller to ascertain all facts connected to the application for reconstituting the dealership in terms of the amended provisions. The allegation of the appellant that the writ petition of the appeal has an alternate source of income is an issue which falls within the obligation cast upon the subdivisional controller in terms of Section 20E. Mr. Sir, I submit that the challenge to the deed of partnership will not lie before the subdivisional controller, etc. Mr. Sengupta Laner State Council, having regard to the clear provisions of the amended section, the appellant does not have an inherent right of hearing. Having heard the parties and considering the materials placed, this court is of the view that the decision-making process directed to be performed by the concerned subdivision in terms of the order of the Honorable Single Bench can be better achieved in the event the appellant is also granted a right of hearing before the subdivisional controller at the time of deciding the issue. Accordingly, the subdivisional controller Kadi Murshid is directed to afford an opportunity of hearing to the appellant with production of documents, if any, while acting in terms of the order dated 13 January 2022 passed by the Honorable Single Bench. It is made clear that the points are left open to be decided by the subdivisional controller. Thereafter, my lord, recalling application was filed by my learned friend.
Yes.
And several order was passed in the said appeal. My learned friend clients also filed one application under section 340.
Recalling order of what?
Recalling order of the division bench order, which I have shown before your lordship, which I have just pointed out before your lordship. They filed an application for recalling the said order.
Yes.
Thereafter, my lord, the matter was continuing. They also filed one application under section 340 of the Code of Criminal Procedure. We also filed one application under section 340 of the Code of Criminal Procedure. Ultimately, lordships directed for all compilation of the all orders and records, etc. But there the matter was not heard. In the meantime, the original MR dealer, Mr. Abdul Mukhtar, died. That ends.
Yes. So what is the fate of the recalling application?
My lord, that is pending till date. Appeal is pending. Order नहीं होता है. अच्छा. Okay, order gulo नहीं है. Oh, 25 to 31. Let's kindly come to page 30.
Yes.
Page 30, lordship. One order is there. Several orders is there. Ultimately, one order I have annexed. Party was representing their order. Mr. Bhattacharya Learned Council appearing for the respondent with Mr. Podas, the Learned Council produces the inquiry report as served upon his client in compliance with the terms of the provision. This court dated let a copy of the report be retained with the record. Mr. Sengupta Learned Senior Commander appears with Mr. Pal. Third paragraph, accordingly, the state respondent directed to serve a copy of the said inquiry report. Let the matter appear for consideration. Next, under the same heading, hard in part, Mr. Bhattacharya shall prepare a last order I have annexed. Mr. Bhattacharya shall prepare a convenience compilation of documents necessary for consideration on the next date. Mr. Chatterjee shall be granted inspection of the said documents. This has not been done. Page 31.
Yes, what is the matter? What inspection? What inspection?
Report and compilation, all orders, documents, etc. It has been directed to make a compilation and giving me an opportunity for inspection of the said report. That has not been done. Compilation has not been done. I have not taken any inspection because that has not been done, and that is pending as it was. And in the meantime, my lord, Abdul Mukhtar died.
Mukhtar when died?
What
is the date of death?
My lord, passed away on 29/11/2022. A death certificate I have annexed, page 34, annexure T4. My death certificate, page 34, my lord. What? What's not?
Yes.
After the death of father of the petitioner made application for giving him compassionate appointment. Giving him appointment on compassionate ground because he is fully dependent upon the income of his father. That is page 35 to 64.
Yes.
After that, and it was asked by the sub-divisional controller to file an affidavit. Asked to the petitioner to file an affidavit, and to that effect, I also filed an affidavit. That is annexure P6, page 65 to 70. Simultaneously, my lord, the younger brother of the petitioner, namely Shamsul Kobir, without taking no objection from any one of the family members of late Abdul Mukhtar, and suppressing the material facts that he is the owner of the landed property, stone casher machine, and a criminal case is pending against him, filed an application before the office of the sub-divisional controller to provide him the APS dealership instead and in place of deceased father, namely Abdul Mukhtar.
So petitioner when applied for compassionate appointment? What is the date?
My lord, 15th February 2020.
15th February 2023, page 35.
Page 35 to 64, with all documents.
Form C3. Yes.
Thereafter, my lord, the sub-divisional controller asked me to ask my client to file an affidavit. I also filed that. That is page 65 to 70.
65 to 70, yes.
My lord, simultaneously, my lord, that is page 6, paragraph 8.
Page
6, paragraph 8. For lordship's convenience.
Yes.
Simultaneously, the younger brother of the petitioner.
That is the private respondent.
No, here he is not private respondent because in the meantime, my brother also died. And that I am coming, my lord. Lateral.
Younger brother of the private respondent of the petitioner.
My lord. That is Shamsul Kobir, who obtained order first.
Yes.
And challenging his writ petition, I filed appeal. That Shamsul Kobir, who is my younger brother, without taking any no objection from any one of the family members of late Abdul Mukhtar, and suppressing the material facts that he is the owner of the landed property, stone caser, and a criminal case is pending against him, filed an application before the office of the sub-divisional controller for giving him compassionate appointment.
When he filed the application?
But that was not known to me, but Lordships kindly see. Thereafter, he moved a writ petition before this Honorable High Court.
Shamsul Kobir moved writ petition.
My lord.
What is the order?
My lord, the order is, my lord, page 71 to 72.
Page 70.
71. 1 minute, my lord.
Yes.
1 minute, my lord. Yes. Page 71 to 72.
Yes.
Learned counsel appearing on behalf of the petitioner submitter not like to praise this application. Shamsul Kobir file. Petitioner would not like to praise this application and instead pray for a direction upon the respondent to consider the application for obtaining license. In the one hand, he make a prayer that he does not want to praise this application. On the other hand, made a prayer. However, his lordship passed an order. In view of the above, let the respondent consider the application made by the petitioner for appointment as a fair shop dealer and any other application that might have been filed in respect of the said dealership within a period of 4 weeks from this date. Because I also appeared and I made the submission, my application also should consider.
Yes. Thereafter, what happened?
Thereafter, my lord, hearing was taken by page 73.
Personal hearing of Shamsul Kobir, Shamsul Joha, all the
Legal heirs.
All the legal heirs. Very good. Thereafter, what happened?
Thereafter, my lord, my lineman friend's client again moved a writ petition with the same prayer which he made previously. I have quoted the prayer in my writ petition.
Initially, Shamsul Kobir and Mukhtar filed a writ petition. Initially, Mukhtar and Shamsul Kobir filed a writ petition.
My lord.
Thereafter, you file a writ. You file appeal.
Appeal.
You file appeal. In the appeal, there is also direction to disposal consider your representation.
Subsequently, they filed recalling application. Thereafter, compilation of documents, etc.
Who filed the recall application?
My learned friend client, that is Shamsul Kobir, who obtained order from the
Shamsul Kobir filed a recalling application. That application is pending.
That whole matter is now pending.
Pending. Appeal is pending now.
Appeal is pending.
Very good.
With the order I have already shown before your lordships, that was the last order.
That is the last order. So, thereafter Abdul Mukhtar died.
But
so, petitioner, that is you. You are the Shamsul Joha.
The first one.
Muhammad Shamsul Joha. You applied for compassionate appointment. Shamsul Kobir also applied for compassionate appointment. Then what happened? Personal hearing done.
Personal hearing done. In the meantime, he moved a writ petition. No, before that, he moved a writ petition.
The writ petition direction was there to consider the representation.
Thereafter, my lord, the personal hearing was taken.
Yes.
Again, he moved a writ petition after personal hearing was taken. That is annexure P9.
Yes.
It's an elaborate order. Here, my lord, I make submission, which I have submitted before the lordships, that he has the regular means of income, he has the crusher machine, etc. But
no, why he approached the court?
He approached the court as there is no consideration of his application till that date.
Okay, he moved the writ petition for decision of the authority. So what is the order? Again, the direction to dispose of the application. Page 80.
Oh, there are some other directions also. That is page 6, my lord, or page 79.
Yes.
There are some judgments. It is needless to say that matter is still pending before the subdivisional control in view of the judgment passed by the Honorable Justice Joy Sengupta. Any other application that might have been filed respect of the city within a period of 4 weeks. Yes, my lord. That is there. 6 weeks. Food and Supplies Council shall be specifically directed to dispose of the application and written objection from the date of communication of this order. At the time of disposing of the application, subdivision control of Food and Supplies Joint will take note that provisions contained in etc. 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 এটা কে করলো কি টেনটা I filed an appeal against the said order. My client. But what happened, my lord? After filing this appeal, I filed an appeal against that order.
Against which order?
The order of Justice Vivek Chaudhary. Rather than his lordship was.
So direction was to upon the subdivisional controller.
Because I filed that appeal because that is res judicata, because my lord previously moved a writ petition before his lordship, the Honorable Justice Joy Sengupta. There he has not obtained leave to file another petition, etc. etc. However, my case has not been considered. I filed an appeal.
Where is the order?
Well, appeal court has not passed any order. When the appeal is pending, my brother Shamsul Kabir passed it. On 15 February. Yes, my lord. He passed on 18th August 2023.
Yes.
18th August 2023 passed away. Informing the said fact, we made an application because there are 3 contestants. I, my brother, and one of my sister also, who is also the writ petitioner herein. Both of us, my lord, made an application on 23rd August 2023.
Page
181 to 139.
108.
Page 81.
81. Yes.
One matter is fixed at 3:15 p.m. Advocate General is got to argue the case.
Oh, yes.
Okay.
Up to this, we made representation. let today stop, tomorrow I will come.
No, this is your representation, page 81.
81.
It was not considered.
81 to 139. P10. Only Lordship kindly note down it. I will come tomorrow, my lord. Because Advocate General is there. And there is a matter.
Okay, please take down. Argument on behalf of the petitioner continued. Let the matter appear in the list on 16th of July 2025.
16th July.
16th of July.
Same position.
Same position. এখানে পেন নেই একটা পেন্সিল তাহলে এই পেনটা লেখা হয় শেষ হয়ে পেন নেই
That guarantee has 13 part, my lord.
continues.
I'm grateful, madam.
For the petitioner. I have already concluded my submission.
Supplementary.
They have purchased and
নোট করা ছিল হ্যাঁ
এই জায়গাটা বলেছিস?
হ্যাঁ
এই জায়গাটা বলেছিস?
নোটিফিকেশন এই যেখান থেকে
লেভেলকে অ্যাপয়েন্ট করেছিস সেটা কোথায়?
ওই তো এখান থেকে এই যে অ্যাজ করে অবগত সাথে
হ্যাঁ।
Yes.
Milord, your lordship may kindly take prayer C of the writ petition at page 19. Milord, one of the prayers relates to, Milord, certain payments for alleged use of POS machines. A writ in the nature of mandamus commanding the respondents, each one of them, their servants assigns to release and disburse the proportionate additional margin for operation, running, and incentive for integration of EPOS with e-weighing scale and delivery of food grains through integrated weighing scale on and from 1/4/2019 in terms of food security assistance to state government rules 2015.
Yes.
This is one of the prayers. Now this rule, my lord will find at page 48 of the writ petition. Kindly take rule 2G. Point of sale device. This point of sale in short is called POS.
Yes.
Point of sale device means a device to be installed and operated at fair price shops for identification of entitled persons and households for delivery of food grains based on Aadhaar number or other authentication tools specified by the central government from time to time. But this is the purpose of a POS machine.
Yes.
Then please take H, 2H. System integrator means an agency engaged by the state government to purchase, install and maintain the point of sale device at fair price shops in the state. Not my learned friends, clients are fair price shop owners, where Millard citizens like us, they go and get their ration articles. Now, Millard, to bring transparency and to ensure, Millard, that food grains are not diverted for other uses, Millard, this POS machines, they are installed. Millard, they are, Millard, they work along with the weighing scale, which is connected through Bluetooth for the purpose of identification whether the person who is getting the food grain is the actual person or not.
Yes.
Now, please take Millard 6, rule number 6, which no, I'm sorry, rule 7, sub rule 6, which your lordship will find, Millard, at page 50. The state government shall have the flexibility in choosing any of the following models for installation of point of sale device, namely, the state government may purchase, install and maintain the point of sale device. B, the state government may select a system integrator to purchase, install and maintain the point of sale device. C, the fair price shop dealer may purchase, install and maintain the point of sale device. So there are 3 options available. One is the state government itself will buy it and install it, which is not done in the present case. The second is the state government may select a system integrator, which is defined in 2H. But in our state, system integrators have been selected and engaged.
So what is the purpose of system integrator? They will purchase.
They will purchase, they will install, they will maintain.
They will maintain.
Yes.
By their
By their own men.
own persons. Yes.
And the third category is the fair price shop dealer may purchase so and so.
Own personal they may. Yes.
So in our state, we have chosen B.
System integrator.
Yes. Now we have, Millard, engaged 2 system integrators in the entire state of West Bengal. One is, Millard, Rebuttal, and the other is Rebuttal, the other is Linkwell Telesystems Private Limited.
One is Rebuttal.
The other is Linkwell Telesystems Private Limited.
Yes.
Now, these 2 bodies were selected through a tendering process. But my limited submission today is these bodies, Millard, they are paid as per the central government rate. 50% is paid by the central government, 50% is paid by the state government. Now, if my learned friends, prayer is allowed, prayer C at least, then, Millard, we have to do away with Rebuttal and this Telelink. Therefore, Millard, in my very respectful submission, these 2 are necessary parties.
Okay.
So, Millard, I have, Millard, instructed my client, subject to your lordship's permission, to file a supplementary affidavit to bring on record this fact. And your lordship may kindly consider passing of an order to add these 2 bodies as parties to this petition, because if my learned friends client's prayer is allowed, then these 2 persons will be vitally affected. For me, it is nothing. Either I pay these 2 bodies or I pay the fair price shop owner.
At this stage, I have concluded my submission. not
No, if it
permissible
is not
under law.
required, if he feels that it is not required,
Not required.
your lordship may record it and reject it.
Not required.
I don't think that will adhere to, yes. And your lordship is not powerless to add them parties.
No. At this stage, it cannot be.
Very well, your lordship may consider it, record it, and then by whatever your lordship feels will pass orders, appropriate orders.
I have not argued this point also.
Yes, you have not argued at all.
They have, whatever they have done in their opposition. Today, placement of a supplementary affidavit after conclusion of the hearing on behalf of the petitioner is no way permissible in the eye of law.
Let us see whether it is permissible or not.
Sir. Okay, you serve a copy.
Yes, sir. Because otherwise, my lord, whatever is the decision that your lordship will finally, my lord, decide. But my lord, if a party who will get affected,
The only question you must have come first.
yes,
Earlier.
there I agree.
That is the way.
There I agree. There
For
definitely-
argument, if you place this, the Mr. Sahara would not have any point. to
Difficulty is that I have disclosed my defense.
No, who defense is, I am defending.
Super my lord, my case I have already,
defending.
I
How
have,
can he disclose his
I have disclosed my entire case. After hearing the same, if somebody wants to bring some documents to place before the court, I will be prejudiced because I have placed the case on the basis of my writ petition and considering the opposition filed by the state.
My lord,
So
my
today,
learned
at
friend-
this stage, in any manner, your lordship possibly cannot accept any document.
My lord, let my learned friend then make a statement. Kindly record it that in his client's fair price shops, there are no system integrator. I'll be out of
I
court.
shall not make any comments.
Ah.
I shall proceed
Yes,
on the basis
yes.
of my writ petition.
Yes.
And I shall
then
give
do
my
not
answer
object.
on the basis of
Then
the
do not
statement
object.
made in the opposition. I should not make any comment. Under the law, it is not permissible.
Either let him make a statement that there is no system integrator. I will carry on with the argument. I am ready with the matter. There is no doubt about that. But if he does not make that statement,
Okay,
then
okay.
yes, he has to make a
Stage,
has to
no,
take
no,
a
my
stand.
submission before lordship.
So he should have disclosed. I will make an argument that because of this non-disclosure, the writ petition should be dismissed.
That should have been done at the very initial stage of.
Milord,
Not at this stage.
a suppression is
Filing,
a suppression.
reply, filing, reply, opposition, everything has been concluded. Pleading has been concluded. I concluded my submission.
Milord, your lordships have dismissed hundreds and thousands of writ petitions on the grounds of suppression of facts, material facts, not any fact.
After hearing me, a new point is to be introduced before your lordship,
No,
and that has
no,
to
I
be
have not started
absolutely-
as yet.
Why
I
they have not
not
disclosed it in
started
their
as yet.
opposition?
I have not started as yet. I am entitled to take any point under the sky. It is for the court to accept it or refuse it.
I'm praying for rejection of this document.
Yes.
Okay, please take down.
On the ground that at this stage it cannot be. Only that submission.
Please take down.
No, আজকে নেই তো। কালকে।
Let I pass the order on that point.
Yes, yes, no. My lord's officer was asking, inquiring whether today we have a 3:30.
Tomorrow.
Tomorrow.
3:30 is tomorrow.
Please take down. During the course of argument, learned Advocate General place a supplementary affidavit in opposition on behalf of respondent number 1 to 3. 1 to 3. A vehement objection raised on behalf of the petitioner. It is the contention of the learned senior counsel on appearing on behalf of the petitioner that after closure of argument on behalf of the petitioner, the state authority cannot place a supplementary affidavit in opposition. He further submits that at this stage, the supplementary affidavit in opposition cannot be accepted. Learned Advocate General. Submit that the argument on behalf of the respondent number 1, 2, 3 has not yet started, but the person but it is necessary for the state authority to bring certain facts before this court for proper determination of the matter. It is the contention of the learned advocate general that the additional margin fee for maintaining EPOS machine is the subject matter of the instant writ petition. Full stop. The state has adopted a system integrator for providing EPOS machine at the FPS within the state of West Bengal. They are HON'BLE Technology Limited and Linkwell Telesystem Private Limited. Full stop. It is the further contention of learned advocate general without making them party in this matter. The writ petition cannot be heard effectively. Mr. Saharai, learned senior counsel, appearing on behalf of the petitioner, submits that at this stage, the authorities, the persons, namely HON'BLE Technology Limited, as well as the Linkwell Telesystem Private Limited, is not required to made party in this writ petition. Having heard the learned counsel for the petitioner as well as learned advocate general, it appears that the state respondent has already used affidavit in opposition, wherein they have not disclosed the presence of system integer in the periphery of the state of West Bengal. However, during the argument, learned advocate general placed on record some documents wherefrom it appears that the state of West Bengal has already adopted to introduce to appoint system integers in the state of West Bengal for maintaining EPOS machine at the FPS. It appears that though the authorities, namely HON'BLE Technology Limited or Linkwell Telesystem Private Limited, is not a proper party in this matter, but the supplementary affidavit in opposition is required to be considered, is required to be placed on record. Accordingly, the supplementary affidavit in opposition filed on behalf of the respondent number 1 to 3 is taken on record. Full stop. The petitioner is at leave to use reply against the supplementary affidavit in opposition filed by the respondent number 1 to 3 within 2 weeks from date. Let the matter appear again on 28th of July 2025 at 2 p.m. under the same heading.
Or better to appear on
28th.
Same position.
Same position, 2 p.m.
Very well. I'm grateful.
Supplementary opposition tool. Supplementary opposition. কে বললো? শোনো